Court officer.
Then we are
May I make one submission? Or?
just a moment, we'll be calling page wise.
Please. Sorry.
What is the petition? What is the petition about? Labor matter, what is it? Second appeal. Interim order is there by this court. Yeah, have you filed an application for vacating? Have you filed an application? Have you filed an application for vacating?
Yes.
Here the application is pending. And what is pending before the? Advice by the Chief Justice. How can there be an advice by Chief Justice? Yes. Yes.
Second, we are ready to.
It will be listed on next Thursday, next Wednesday. Yes. Yes.
Assignment if any, page wise assignment.
Yes. Fresh matters, old matter would be listed on Wednesday. So Wednesday. Yes. Have they filed their objections? Have the KAB filed their objections? Then let it come next Wednesday. No. What is the year of RSA? Tomorrow.
Institute assignment if any. Page number 1.
First matter will be calling it now itself. The appellant counsel. The counsel submits that parties are seeking for an like the parties here. The learned counsel for the appellant submits that the parties are settling the matter amicably before the final degree court, and there is a possibility of settlement. Then the counsel for the appellant seeks for a short accommodation. List this matter on date. Give the date. Date for it. Tell the date. 12th. See, this is what happens when we give an adjournment for one person, the others is our counsel starts seeking adjournment. No, Mr. Counsel, we will hear you because this is a date given matter. We'll hear you. Ask your senior to come.
Page number 2, serial number 4 to 8.
Admission matters, please don't ask adjournment. Give it in only final hearing.
Page number 3, serial number 12.
Serial number 2 ಆದರೆ ನಂದು ಇದೆ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ದಲ್ಲಿ
Is this number 2?
Serial number 12 final hearing matter. I am not seeking for adjournment. I am seeking permission of the court to appear. I want to physically appear. Afternoon session I want to appear before the one.
We'll take your matter at 2:30.
Please, I'll.
You inform the other side.
I have informed.
Yes.
Page number 4, serial number 13 to 15. Page number 5, 16. Page number 6, serial number 17 to 23.
Serial number 23, I will send fourth. 23.
Request of the appellant counsel, list this matter on fourth.
Page number 7, serial number 24.
Fourth list.
4.
The fourth list, kindly mention the dates when you all want.
But serial number 19, my lord, 19, my lord. Kindly on the fourth, my lord, that is next week. I have spoken
What
to
is
the
the-
opposite council
What is
also.
the extreme urgency for,
No extreme emergency. I am the,
so take it after 12.
please, 12th,
Which is the convenient date after 12?
12th.
12. Please, is this matter on 12?
Your
lordship, serial. 15, huh? Your lordship, serial counsel for the petitioner. What is that you have complied?
About 25,000
What was the direction now?
I have to pay the amount available before pay. In advance, I have paid the.
No, and we were directed to take hand summons as well.
It was not available.
Then what is that needful you have done today?
PFP.
Only PF, you have to also take
I
the
will take the.
petitioner on the first order sheet. Ah,
Serial,
I have one career.
serial number 14, my lord, if your lordship.
Wherever there is an interim order to be extended, it would be extended. And if there is an extreme urgency, kindly mention, otherwise the matters would be listed after 12.
My lord, serial number 11.
Serial number 27.
We'll call one at a time. Serial number 1.
Serial number 1, Partition.
When do you want, Mr. Consul? List this matter after date for it.
When September.
Interim order granted earlier is extended to the next date of hearing. Mat karo.
Serial number 2, for admission with other HP.
When do you want? 12. 12.
Serial number 11. Serial number 3.
Ah,
Number 3. Nothing, Raju.
Yes, Mr. Narasimha Raju. No appearance on behalf of the petitioner. List this matter in the week commencing from.
18. 18.
Yes.
Number 4, Raghunath MP.
Yes, Mr. Raghunath. Is there an extreme urgency in this matter? Was it heard? Or was it heard before the earlier hearing? Then take your chance tomorrow. Please. List this matter tomorrow.
Number 5, Vasan.
Yes. Not first week, after 12th, any day. 12th. Yes, Mr. Rajshekhar.
Action arrest.
What is that extreme urgency? Was this appeal heard by the bench? It's Monday.
Serial number 7, Manjunath.
Yes, Mr. Manjunath, no appearance on the either sides. Does this matter? The week commencing from.
Serial number 8, Ali Patil.
Mali Patil,
PPL.
no appearance on either side. Does this matter in the week commencing from.
For order, serial number 9, P. Basurajappa.
Yes, Mr. Baswarajappa.
Serial
Paper
number 9.
publication. It could be there. The appellants have not filed the citation for having taken the paper publication, the Kannada daily newspaper. Order dated 9/7/2024. Either there is appearance on behalf of the applicant. List this matter up to close.
Number 10.
This, what is this? Await service of notice in respect of respondent number 4. A week's time is granted to the learned counsel for the appellant to take steps in respect of unserved respondents 3, 5, and 25 within a week. Interim order is there. Interim order granted earlier is extended to the next date of hearing. Yes.
Number 11.
For the appellant's manner, can we have it on trial?
You have to take steps.
But after hearing, manner, there's a fabricated bill that
The correct notice was ordered, right?
no, madam.
Then why is it coming for furnishing of process fee? Why is it coming for furnishing?
Last week, the first on I manner was required. Then the hearing after serve the notice.
Interest of the appellant counsel, this matter on 12.
Number 12. Nothing appear.
You don't want to press this petition? You file a memo to that effect. Learned counsel for the petitioner submits that the petitioner does not intend to prosecute the present petition and files a memo to that effect. In light of the submission and memo filed, the petition is dismissed as withdrawn. Yes.
Number 13. Kumar H.
Await the service of notice in respect of respondent. Yes.
Preparing for the respondent.
12. Manjunath, this is fourth list, counsel. Yes, Mr. Arun Govindraj.
Yes, preparing for the respondent, madam. 5th, yes, madam.
Is this matter on 5th?
5th, madam. That's all right.
Application on both sides.
Raja. 16.
15 and I thought.
Interim order is in there. Applied bill.
Serial number 15.
The complaint with Millard, today 25,000 is time for you. Because the order, I complained already, I paid 1,50,000. Today, I transferred in advance, yes, paid.
We'll list it tomorrow. List this matter tomorrow. Tomorrow. We will see. We don't know what has transpired before the court. Tomorrow. Next. Monday. List this matter on Monday. Yes.
Appearing for the petition, madam. Interim order may be extended. I've also sent email copy to the respondent. The same is been furnished.
Await service of notice in respect of the sole respondent.
Yes, madam.
Await notice in respect of sole respondent. Interim order granted. In the next date it is. No, it says if you comply this order, you will.
Lordship, I have deposited 15,000.
So then there is an interim order. We may not say anything. Await
18th
service of
September, my lordship.
Is this matter after service of notice? What is this non-filing of memo filed by the advocate for the petition? Where is the acknowledgement? Then you have to file that, right? When do you want? 18th, list this matter on 18th. If order granted earlier is extended till the next date of hearing.
Number 18.
Appear for petitioner Millard. Millard, they have not received the summons, Millard, and summons.
To await service of notice. You file an acknowledgement that they have refused to take accept notice.
Yes,
Have
madam.
you await service of notice in respect of respondents 1 to 3. Yes. Next.
Right, serial number 90. Serial number 20.
12th, huh? Yes. Issue emergent, whose petition is this? Wife's petition. Issue emergent notice on I-1 of 2024 as well as the main petition. Returnable by. 18. Yes.
Serial number 21.
Ah. When do you want this matter? Monday, you take your choice on Monday. Monday. Another 2 days, nothing will happen, right? Monday.
Number 22.
For the respondent in this matter, my lord. 1 week time may be given, my lord, in this matter.
There's extreme.
Visitation rate, sir.
No, not visitation rights. The child is suffering in this matter. Lots of Monday, my lord.
Okay.
I post on Monday, my lord.
Is it listed for dismissal? Why is it? No, because you did not appear, the matter was listed for dismissal. Mr. Bhuvan. You're Mr. Bhuvan, right? So this order is on 12/8/2024, indicating that you were not present before the court and the matter is listed for dismissal. In light of the presence of the, you go before the court itself tomorrow. This is not. This Mr. Harish. Tomorrow.
Number 25. Party person. Petition.
Party in person is not present. Is this matter? The week commencing 12th and 30th. Is this matter on 12th?
23. Yatraj B. Serial number 26. Yatraj B.
Tomorrow for dismissal. No representation. This is the matter for dismissal.
Matters, number 27.
Other all matters from 27 to 31 would be taken from 12th, after 12th. Yeah. 29th on 5th. And 27? Their name is already indicated as Ramappa. Somebody has filed power for the respondents. Is this matter on 5th? 30? When is it listed? MFA list agidya. What is listed? Where is it listed? Andhra Pradesh. When do you want this petition? After the 25th.
25th September.
28th. When do you want? Sorry, 18. In the week commencing from 18. 31st, 31?
31.
12. Yes. And this one, and this two already. This should say. No, we will call those matters. Kindly wait. Those are the, kindly wait, madam.
3. Fresh matter serial number 1. Padmavati Suresh.
Collected matters may be subject interim stay in particular. Interim stay subject to the petitioner depositing entire compensation amount as awarded by the trial court with interest at the rate of 8% within 4 weeks from today before the trial court.
Bill number 2, MB Nagesh.
Yes, Mr. Nagesh, your interim prayer and the final prayer is one and the same. So this that petition becomes ನಮ್ಗೆ ಓದಿಸ್ಲಿಕ್ಕೆ ಹಚ್ಬಿಟ್ಟಿದ್ದೀರ. We had to read the fact. Mr. Nagesh. Petitioner seeks to withdraw the petition and files a memo to that effect. Light of the submission and memo filed, the petition is dismissed as withdrawn. SCGP to accept notice for respondent number 1, Harish Bhandari for respondent number 2. Learned counsel.
Bill number 3, MB Nagesh.
Yesterday's matter that you will not sit as that.
We'll dispose of this matter on. See, one ಸ್ವಲ್ಪ legible ತರಬಾರ್ದಾ? ಏನ್ ಗೊತ್ತಾಗತ್ತೆ ಇದ್ರಲ್ಲಿ? ಅದನ್ನ ಜೆರಾಕ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೂ ಇಷ್ಟ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ?
ಏನಾಗಿದೆ ಅವ್ರಿಗೆ rationalization ಮಾಡ್ಬೇಕು.
Who accepts notice? Not to precipitate. SCGP is directed to accept notice for respondents number 1 and 2. Harish Bhandari P. Learned counsel is directed to accept notice for respondent number 3. Petitioner counsel to serve the writ petition papers on the learned counsel appearing for the respondents. Learned counsel for the petitioner submits that in identical matters in WP 21818 of 2024, this court has directed the respondent number 2 not to take any precipitated action pursuant to the impugned order in the next date of hearing. In order to maintain parity, there shall be a direction to respondent number 2 not to take any precipitative action pursuant to the impugned order till the next date of hearing. This matter along with WP 21818 of 2024. This matter on 4th.
Order, serial number 4, Lani.
Who is respondent number 5? You don't want to take notice for respondent number 5?
My request is the matter will be remanded, we can convert that for the first. Because if when I think only the problem was issue was regarding building error, it is under renovation. Hence, the matter will be remanded just for reconsideration matters for before the first respondent.
Where is annexure? Annexure.
Thing is under renovation. The process is in air.
Now, who has to consider your application in light of the dismissal of this appeal? You have to give.
We will make fresh application before the exchange commission.
Correct. You make a fresh application, then we will consider yours. Alva.
Since this petition is pending, they cannot be considered.
Then what is the course available to you? You have to withdraw this petition.
Since the building is
What is
not
that?
like
Madam Sudha, you have to withdraw this petition with liberty to file necessary applications.
that's what I'm.
But you said you will have to remand the matter. Where is the question of remanding the matter now?
The matter will be disposed of and even if it becomes, we will file.
After arguing the matter for some time, then counsel for the petitioner seeks to withdraw the petition.
Withdraw means they will not consider.
With liberty to file necessary application for renewal, right? For renewal. The petition is dismissed as withdrawn with liberty to the petitioner to file necessary application before the authority and the authority to consider the application in accordance with law. Merits ಅಂತ ಹೇಳಿಲ್ಲ you have been given liberty.
The first respondent.
To the first the respondent number 1. Give an application to respondent number 1. Seeking renewal of CL-7 license. And if such an application is filed, the respondent number 1 consider the same and pass orders in accordance with law.
Number 5, Substitution.
My lord, I appear for the petitioner.
Mr. Somsekar.
In this, I had to file statement of objections to the IEM, my lord. The representative, author representative of the monitoring committee objective is appointed by the NCLT is out of station at Bombay, my lord. I have sent the objection statement.
On the last occasion, we granted
Yes,
you
ma'am.
time.
Ma'am, last time also I requested because they, at that time they instructed me to appear, my lord. I have sent
Yes,
the statement
time.
of objections.
Time, Mr. Somsekar.
My lord,
2 weeks.
17th if it is posted, he is coming, he is out of station. He is coming on 11th September, my lord. 17th if it is posted. Before that, I'll serve a copy to Mr. Prashant Rao and argue
Yes.
the matter on
One of
17th.
24 for direction is filed by Prashant Rao party in person. There is no representation on behalf. There is no representation. Learned Counsel Somsekar appearing for the petitioner 6 times to file objections to I-1 of 2024. As a last chance, the petitioner is granted time to file objections to be
On
filed
17th.
for 17th September 2024. This
Much
matter.
Much obliged.
Number 6, Ananda Devi.
Yes, Mr. Anand. Yes, sir. Connected matter, Amanda Basin. Court officer, correct? The petition. In the petition. The petitioner in WP 19949 of 2024 is the objector for grant of CL-7 license to the respondent number 7, Messrs. ANR Bar and Restaurant, who is the petitioner in WP 21897 of 2024. The brief facts for consideration of this repetition of these petition is narrated as under. The objector and respondent number 7 had filed WP 26276 of 2023 and WP 25276 of Seven 262 of 2023 first one. 25726. Correct, first read is
26276 of 23, 25762 of 20.
25726. 2023 respectively before this court. This court-wide order dated 20th December 2023 disposed of the writ petition with the following observation. While disposing of the writ petition, this court observed that the Deputy Commissioner, while considering the application of the petitioner, bracket nulli, respondent number 7, bracket complete, to operate CL license must extend due opportunity to both the applicant and the objector to file their response to the reports called for in that regard. Full stop. Pursuant to the order passed by this court, the respondent number 4, 5, and 6 submitted the report to respondent number 3. Respondent number 3. The Deputy Commissioner of Excise, comma. Respondent number 3 issued an endorsement that in the event the respondent number 7, bracket nulli, petitioner in WP. What is that petition? 21897 of 2024 rectifies all the faults as reported by the respondent number 5 and 6. Respondent number 5 and 6. And proper documents are filed, comma, the application as per the rules would be considered and rejected the application of respondent number 7, petitioner in WP 21897 of 2020. It is the submission of the learned senior counsel Jaikumar S. Patil that for the objector that while considering the application of respondent number 7, bracket nulli, Mrs. ALR R and Restaurant, an opportunity needs to be extended to the objector. Next, respondent number 7, who has filed the connected petition, is seeking for a writ of mandamus. Directing the respondent authorities to grant the petitioner request for grant of CL7 license at premises of VP Khata number 128, E7 number 1, other extract not very numbers, page number 18 of the writ petition 21897 of 2024. The grievances of the objector and the petitioner in WP 21897 of 2024 would be meted if necessary direction are issued to the respondent authorities to consider the representation of the petitioner for seeking grant of CL7 license, and if such an application is filed, and while considering the application, the objectors to be extended an opportunity to file objections and to be heard, and the respondent authorities to pass appropriate orders on the application in accordance with law within a time of 4 weeks. CL7 license for 4 weeks, within 4 weeks, 6 weeks from the date of release of this order. Writ petition stands disposed, and accordingly writ petition stands disposed. What is that? Yeah. So respondent number 2 to consider and that. Any respondent's authority of respondent number 2. Okay, first order sheet writ petition in order in WP 21897 of 2024. Order sheet you take notice for learned SCGP is directed to accept notice for respondents number 1 to 4. And whom do you appear? Who is the respondent number 5? Ulpur Gram Panchayat Somya Ji. is directed to accept notice for respondent number 5. 2 weeks time is granted to file wakalat bar memo of appearance. In light of the disposal of the writ petition, the pending heirs, if any, not survive for consideration.
In detail.
Possible. Final hearing, I mean, for an objection of the first, which one?
Order. Yes, Susma.
Is
Yes, the appellant paid 3 weeks.
this paper books necessary in this appeal? It's necessary. At request of the appellant counsel, 3 weeks time is granted to file paper books, failing which the appeal stands dismissed without reference to the bench.
The name of the advocate on record may be deleted and mine and
What is your name? Have you filed wakalat? So and so counsel, first, so and so counsel submits that he has filed wakalat for the appellant registry to delete the name of DS Cosmet, since so and so counsel has filed wakalat for the appellant. Then the counsel or Hesser seeks 3 weeks. Yes.
Number 2. CM Nagabhushana.
Is Mr. Nagabhushan? No representation on behalf of the appellant. A week's time is granted to rectify the office objections raised on I number 1 of 2020, failing which the appeal stands dismissed without reference to the bench. Yes.
Number 3.
Issue court notice to the appellant returnable by
18th September.
18th September.
Number 4. Government advocate.
Await service of notice in respect of proposed respondent number 1 A to B.
Number 5.
A week's time is granted at request of the appellant counsel to rectify the office objection raised on I number 1 of 2020, failing which the appeal stands dismissed without reference to the bench.
So far as the kind of paper books are concerned, my lord, it's for 4 weeks of operation.
Is paper books
Yes, yes.
necessary? 4 weeks time is granted to file paper books. Yes.
Number 6. Irana basically.
Well, the customer compliance to rectify on I number 20. A week's time is granted and 4 weeks time is granted to file paper books, failing which appeal stands dismissed. Yes. What is this? You are appearing for the respondent number 1. When did he die? When did respondent number 2 is reported to be dead long back. No steps have been taken. Appeal stands abated as against respondent number 2. You need to file your objections. It's of the year 2016. Respondent number 1, counsel seeks time to file objections to I1 and 2 of 2016. At request, 2 weeks time is granted.
Number 7. Giridhar SP.
Yes, Mr. Giridhar. Notice has to go to the respondent 2A. Notice has to go.
Yes.
Memo is filed stating that the appellant number 2 is the legal heir of appellant number 1, who is the son. The memo is taken on record. Appellant number 2 is treated as the legal heir of appellant number 1. Appellant counsel to carry out the amendment and file amended constituted within a week. Issue notice on I number 123 of 2018 to the proposed LRs of respondent of respondent, proposed LRs of deceased respondent number 2. Turnable by.
In September.
Yes.
Then number 8, R. Vaibhav.
A week's time is granted at request of the appellant counsel to do the needful to rectify the office objections. Which is for process fee. Kindly do it today itself. It's not appellant counsel to do the needful during the course of the day.
Tomorrow.
A day's time is granted to the appellant to for compliance of the office objection in respect of the process fee. Failing which,
The process fee.
failing which the appeal stands dismissed without reference to the bench.
9, Srinivas.
Yes, Mr. Srinivas. Appellant counsel seeks time to take service of notice on the unserved respondent by way of paper publication. At request, a week's time is granted. There is a delay of 1,892 days in filing the appeal. Yes.
Then, M.N. Madhusudan.
Yes, Mr. Madhusudan. When did respondent number 4 die? The respondent number 4 is reported to be dead long that no steps have been taken. Appeal stands awaited as against respondent number 4.
11, State Committee.
Non-furnishings. And what is this non-furnishing of PF to respondent number 2? Non-furnishing of serial number 11, right? Serial number 11. Non-furnishing of process fee. Correct. Respondent number 1 is abated. You have to take process. 2 is abated. Huh? Where is it? ಯಾರು ಸತ್ತಿದ್ದಾರೆ R1 ಸತ್ತಿದ್ದಾರೆ R2 ಅಲ್ಲಿ who is 2 respondent number 2 he is also dead. Even R2 is dead. So 1 and 2 son and father is dead. Then who are the legal heirs now? Are you filing it? Appellant counsel submits that he is filing applications to bring the legal representative of respondent number 1 and 2. Yes. At request, a day's time is granted. Stop. File it.
Then number 12, Shankar Narayan Bhatt.
4 weeks time is granted to file paper book. Failing which the appeal stands dismissed without reference to the bench. Yes. At request of the appellant. What is the interim order? You have not complied the interim order. No. You have to file an acknowledgement. Allah. Practice, Mr.
This was ordered passed in 2016 and 17, and within we have published security before the lower court. That as per the order, because the property before the trial court. That is done. I inquired in the party and it said yes.
Correct. You have to furnish the acknowledgement. Until you furnish that acknowledgement, that is a conditional order that you have to pay the decretal amount which is passed by the trial court within 15 days from the date of receipt of this copy of this order. There has to be an acknowledgement. The party tells we accept, we cannot. We have need to an acknowledgement for that effect. We need an acknowledgement. Pass over, you file an acknowledgement. Otherwise, we are not. Then you file that acknowledgement and then we'll exchange. the learned counsel for the appellant 6 times to furnish the acknowledgement for having complied the order dated 4/1/2017. At request, list this matter next week. Okay.
Serial number 30. K. Mohan.
Filing a memo. Memo is filed stating that respondent number 2 to 4 are the legal representatives of respondent number 1. The memo is taken on record. Respondent number 2 to 4 are treated as allies of respondent number 1. Appellant counsel to file to amend the cost title forthwith and file amended cost title. No, amended cost title, carry out amended forthwith. Yes. What is that? I-1 of 2016 is filed to condone the delay of 10 days in filing the appeal. No objections have been filed to I-1 of 2006. Reasons indicated in the affidavit accompanying the application is accepted. Delay of 10 days in filing the appeal is condoned. Accordingly, I-1 of 2016 is allowed. Post the matter for admission. Next.
Serial number 14. P. Sridhar.
Yes,
Appeal
Mr.
for the appellant. I pray for 4 weeks time, my lord.
4 weeks time is granted to file paperwork, failing which the appeal stands dismissed without
My
reference.
lord, such a preemptory orders cannot be passed in the my respective submission.
It's
Even it
appeal
should
of the
come
year
after
2016.
it should come after 4 weeks to know even if there is anything for at least for dismissal, as per Supreme Court judgment. It has to come before the court. Finally, order has to be passed by the court and not
Yes.
a preemptory order, my lord. It's
Yes.
my respective.
Yes.
C. Sudhi Hegde. Miyagata.
Ah. Memo is filed by the advocate for appellant in respect of deceased respondent number 7 and 29. What is that? What is that?
Not getting the case of the last one awaited against 27 and 29. So for a 3 weeks, it's still alive.
You have to file an affidavit to that effect. If respondent number 3 is alive,
But no, suppose they have brought it to the office on the reported.
when was this order passed? Number 3.
The memo. Thereafter, the matter came up and they had to verify it. So after
Number 1, 11 and 34. In February 2024, was submitted by the respondent counsel that respondents 3, 27 and 29 have died. Yes. Now it's your submission that 3 is not dead.
Yes, 3 is not dead. 27 and 29, we have been checked they are dead, but we are not going to be able to get the details of the so therefore it would stand awaited so far as 27 and 29.
And what you say regarding that? Look at when you make a submission to the court, you have to say the genuineness whether he's really dead or not. Now one says he is dead and other says he's alive. Then both of you file an affidavit to that effect saying that he's alive, dead, and you let him file an affidavit that he is alive. Then how are we to ascertain? Let it be alive, Antala. There is an order of this court saying that you have made a submission and then they were directed to take steps. So now you have to state whether he is alive or not alive. So death, if he is dead, there will be a death certificate. If he is alive, there cannot be anything other than saying that he is alive by way of an affidavit. Well, that is why when a counsel makes a submission to the court, he should be very careful. And there's an order of the court now.
Number 2 is the wife. Number 3 also shown as wife of woman.
We don't know whether he's alive. No, you have to ask your party. You have to ask your party who has informed you that respondent number 3 is. Now that you say that if he's dead, file a death certificate. Let him file a application then. How is the appellant supposed to know? You just tell what this court has to do now, in light of the submission made by the respondent. Yes, Mr. Counsel.
What exception, what kind of say of compensation? If 29 and 30, it's a better than the and only because to restore the 3, the school whether it's right or not.
Correct.
And
How do you say that she is dead? There should be a death certificate. Where is the death certificate? You produce the death certificate, then they will file necessary action. What should we do of this order? No, but then your submission was made. Your submission was recorded. The submission is recorded here. The order sheet reveals that you made a submission. What do you want this court to do? Memo is filed by the, and that is on basis of your memo. It's not that you have just passed, you have just submitted and then the court recorded it. Now there's a court order, there's a memo filed. You have to justify that he is dead. Of the memo filed by the respondents. This court passed an order on 22/2/2024, recording that respondent number 3, 27 and 29 are died. Memo is filed by the appellant stating that respondent number 3, Srimati Jayalakshmi, is not dead and she is alive. Further, it is stated in the memo that in spite of the appellants diligently inquiring regarding the names of the legal representatives of the deceased respondent number 7, C. Lingaya, and respondent number 29, Srimati Sushilamma, the appellants are unable to secure the names of the legal heirs who are representing the estate of the said respondent. And submits that the aforesaid appeal needs to need to debate against respondent number 27 and 29. The memo is taken on record. The appeal stands abated as against respondent numbers 27 and 29, as they have died long back and no steps have been taken. So far as taking steps to respondent number 3 is concerned, the time was granted to the appellant to take steps in respect of deceased respondent number 3. And in light of the memo now filed, indicating that respondent number 3, Srimati Jayalakshmi, is very much alive, the appellant to file affidavit to that effect. And on such filing of affidavit, the question of taking steps in respect of deceased respondent number 3 would not arise. Alleged. Within a week, file an affidavit within a week. 2 weeks, file an affidavit within 2 weeks.
See? Kunja?
You have done it today? Appellant counsel submits that needful has been done. Office to verify and proceed.
Bill number 70. Second number deal.
Yes, Mr. First time process करते हैं. Representation on behalf of the applicants. This court on 29/5/2024 issued notice to the respondents. The appellants have not paid the process fee in compliance of the order dated 29/5/2024. Finally, a week's time is granted to do the needful.
My lords, appearing for the appellants in the matter, a week's
Yes.
time may be granted to comply with the office objections, my lords.
Serial number 18.
Please, my
What
lords.
is the office objections?
The first office objection is that the LRs of respondent number 1 has not been steps has not been taken to bring the LRs on record of R1. The respondents number 2
Kindly
to
read
4.
kindly read the cost list. For why is it listed today? Why is it listed today?
Non-taking of steps, my lords.
So that is it regarding the compliance of the office objections?
I'm sorry, my lords. It's regarding non-taking of steps.
Then how did you make
the
a
LRs
submission that, how did you make a submission that office has raised so objections?
my
What
apologies, my
places
lords.
you made a submission, Mr. Counsel?
Apologies, my lords.
When did he die, respondent number 1?
My lords, I'm not aware, but the LRs of respondent number 1 are respondents number 2 to 4, my lords. I'll file a memo in relation to the same, my lords.
To the respondent number 1 as written with the postal Shara deceased on (2019) itself. Move that it stands updated as against this month. Yes.
I see. Madhusudan Rao.
Yes, Mr. Madhusudan. Full cost title hardship. Appellant counsel to rectify the office objection raised on I number 1 of 2023 by a week.
Somshikara. Serial number 20. Ian Somshikara.
No appearance on behalf of the appellant. A week's time is granted to rectify the office objection on 1 of 2023.
I'm for the appellant in this case, my lord, serial number 21. A week's time may be granted, my lord, to furnish the.
When was the notice ordered by this court?
That the steps was taken, my lord. Subsequent to that, correct address to be furnished. I will verify with the documents and I will issue, my lord.
Notice on the year 2019. A week's time is granted to do the need in respect
Please.
of answer response.
22. SCPS.
Defendant number 5 notes is not by party in arrears.
Defendant number?
3, 4, and 6. But the lowest place ex parte. Is not made as party in the array. So, my lords,
Whose appeal was,
appeal.
but then defendant number 1 and the other defendants would be sailing together.
No, my lord. Defendant number 5, my lords, is the son of the defendant number 1. So the Mallegowda, son of Sanjay Nandegowda, my lords, let's see the plaintiff.
Plaintiff is Nanjamma.
Nanjamma, wife of Sri Nandegowda. So the Mallegowda is son of Nandegowda. Defendant number 5 is sailing with the plaintiff.
In spite of that, you have to make everybody as a party.
I agree, my lords. The RA, my lords, they have not been there.
But then you have to make them as a party. You have to take, you have to implead all the respondents and then seek for dispensation of notice to particular respondent. You cannot say that you are not making them as a party in this.
But in respect of respondent number 11, the RSL, there is one more second the objection, that non-arraying of R4 of RA/R11 of RSA is not party to OS. But she is a subsequent purchaser of a property from the partition.
When did you purchase the
After
property?
the OS.
And you have to file an application. See, you have not implemented them in the regular appeal, right? You have implemented them.
No, she is as a regular appeal.
So you give a note to that effect. Have you given a note to that effect?
Yes. I'll give that one.
So give a note and we'll accept it. Appellants to rectify the office objection by a week.
First appellant died, and one of the other appellant, he came and withdraw the appeal. But here what happened, remaining appellants, we have to get a signature of memo. That is the reason I told them to get all the signature and also bring the other card also, plus death certificate. So I think so that I will
That was a submission on 23rd.
last time is one ನಾನೇ ಮಾಡಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಮಾಡಿದ್ದು ಬಟ್ ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೇನೆ ಯಾಕೆಂದ್ರೆ ನಾನು ರಿಸ್ಕ್ ತಗೊಳಕ್ಕಾಗಲ್ಲ ಅದಕ್ಕೆ ಅವ್ರು ಅಷ್ಟು ಬಂದು ಸೈನ್ ಮಾಡಿದ್ದಾರೆ ಮೆಮೋಗೆ ಅಲ್ಲಿ ಕೊಡಬೇಕು.
Appellant counsel seeks time to file memo bar application for withdrawing of this appeal with the signatures of the appellants. Seeks for a short accommodation. Is this matter on? 5th. Yes, 5th.
Number 24.
I am appearing for the appellant, my lord. In this case, of course, there is office objection. I will comply within 2 weeks. Now, meanwhile, one more submission, my lord. Just morning I learned appellant number 2, respondent number 1 and 2 also dead. I have directed them to secure the death certificate, etc. Your lordship may kindly give 2 more weeks so that I will comply. 2 weeks, your lordship may. Date of death is not known to me.
Who has died? 1 and 2?
Appellant number 2 and respondent number 1 and 2.
Appellant number 2 and respondent number
1 and 2.
Approved. Then who remains now?
The 3 and 4 are there. I will examine and make a submission.
Yes. We will record your submission.
Yes,
That
much obliged.
appellant counsel submits that appellant number 2 and respondent number 1 and 2 have been reported to be dead recently and seeks time to take necessary, seeks time to file necessary application. At request, 2 weeks time is right.
Number 25.
Two times notice. You have to take 3 times.
The request your application may be kept, my application may be kept in advance. If it is not, I will take steps further. If it is not served, then the application may be filed. The application may be kept in advance.
The notice was issued to respondent number 5 twice, and the present application is filed by the appellant seeking paper publication in respect of respondent number 5. pending consideration of I number 1 of 2024, seeking paper publication. The appellant is permitted to pay process fee in respect of respondent number 5.
It is Harish HP.
What is this recalling?
For filing the paper book, I have filed the paper book and paid the cost. Damages and it's took for specific for.
Bit of the pre-entry order, it seems.
For the pre-entry order. So on the date was very, I couldn't file it now.
How can you object for this recalling applications? Client kya kya? You were present. Huh? Or dismiss ageda. In objections will impose cost on you then. Nimdu ನೀವು ಆ ಕಡೆ ಬರ್ತೀರಲ್ವಾ ಬರ್ತಿರ್ತಾನೆ will you not come this side ಅಲ್ಲ will you not come this side ಅವಾಗ ಏನ್ ಮಾಡ್ಬೇಕು ಅವಾಗ recall ಮಾಡೋದು ಬೇಡವಾ it's all on technicalities. See, the conditional order we pass so that you comply. It's not that we really want to dismiss the appeal. We see that the appeals have been complied, all the technicalities have been complied. That's the reason we give a conditional order. If you don't give a conditional order, it will never be complied. Take it from me. Yes. I-1 of 24 is filed to recall the order dated 4/7/2020. This court dismissed the appeal as a preemptory order was passed and the counsel for the appellant has not filed the paper books nor paid the cost. Learned counsel for the appellant submits that the paper books have been filed. Filed on
25th July.
25th July 2024, and the cost of ₹1,000 has been paid on 4/7/2024. 2,000, 2,000.
What is the application?
Since the valuable rights of the parties are involved in the present appeal, and the appeal cannot be dismissed on technical grounds. In light of the same, the reasons indicated in the affidavit accompanying the application is accepted. Accordingly, I-1 of 2024 is allowed. An order dated 4/7/2024 is recorded. Appeal is restored to file. Post the matter for final hearing on dated 19th. Yes.
7.
Yes, Mr. Manjunath. Who has died? Appellant number? And what is regarding appellant number 1? In compliance, though? What is the compliance of appellant number 1? You have not filed wakalat for appellant number 1. That is the office objection. Legal heirs ge hakbekalva. Appellant number 1 you must have appeared. He is dead. Now you have to file application. And in respect of appellant number 2, you are filed the wakalat for the legal heirs. Will allow this application. I-1 of 2023 is filed to condone the delay of 124 days in filing the LR application of deceased appellant number 2. I-2 of 2023 is for setting aside abatement. I-3 of 2023 is to bring the LRs of deceased appellant number 2 and record as appellant number 2A to E. Learned counsel for the respondent. No objections have been filed to the applications. Third, reasons indicated in the affidavit accompanying the applications are accepted. Delay of 124 days is condoned. Abatement is set aside, and a loss of deceased appellant number 2 are permitted to come on record as appellant number 2A to E. Accordingly, I-123 of 2023 is allowed. Appellant to carry out amendment and file amended cause title forthwith. Amended cause title forthwith and file amended cause title within a week. Appellant counsel is granted a week's time to rectify the office objection based on I number 1 of 20. To that non-payment. Kodbekalva cost. Please. Do it during the course of the day. Appellant to pay the cost of ₹200. In additional cost, you have to file application for recalling. Per day, ₹100. Additional 100. Yes.
Number 20.
Like you, Narayan Swami. Please. Appeal is admitted. Admitted. Matters to be listed for admission. Of what? IA. We list it on for admission. Please the matter for admission along with I2 of 2016. Appellant counsel to serve the appeal papers on the learned SCG. Yes. Please list this matter on 12th.
29.
Yes, Mr. Narayan Sharma. The objective. Application, appellant.
That's what we come on with.
I-1 of 2023 is filed to condone the delay of 406 days in filing the LR application of deceased appellant. I-2 of 2023 is for setting aside abatement. I-1 of 2023, no? LR 2023. Three application all filed on in the year 2023 itself.
Come on record, I filed it on in 2020.
Well, you filed all this delay after so many days.
Filed an application, the outside raised an objection, and then it was application was required for consideration. Then I filed 2 more applications.
I-1 of 2020 is to file to bring the LRs of proposed appellant on record as appellant number 1, A1 to A4. Yes. Heard. Heard. No objections have been filed to I-1 to 1 of 2023, 2 of 2023, and 1 of 2020. Reasons indicated in the affidavit accompanying the application is accepted. Delay of 406 days is condoned. Loss of deceased appellant. Abatement is set aside. Loss of deceased proposed appellants are permitted to come on record as appellant number 1, appellant number A1 to A4. Accordingly, I-1 of 2023, I-2 of 2023, and I-1 of 2020 are allowed. Appellant to carry out amendment forthwith and file amended cause title within a week. Delay will condone. I-1 of 2017 is filed to condone the delay of 5 days in preparing the appeal. Reasons indicated in the affidavit accompanying the application is accepted. Delay of 5 days in filing the appeal is condoned. Accordingly, I-1 of 2017 is allowed. This is the matter for admission. I-1 of, if he's giving you the copy of the IA, you can have the liberty of looking into it. I-1 of 2019 is filed to bring the LRs of deceased appellant on record. Learned counsel for the respondent has no objection to allow the application. Reasons indicated in the affidavit is accepted. Accordingly, I-1 of 2019 is allowed. LRs of deceased appellant are permitted to come on record. Appellant to carry out amendment forthwith and file amended cost title within a week. I-1 of 2018 to be heard along with the mail. This is the matter for final hearing. Yes, next. 13. 1/3/13.
30th September.
1/3.
Two. For patients, the number 1 adjourned. Number 2, common extension. Serial number 2, distribution serial number 2.
Password.
3. Validity.
You've got the file with you. You don't have the file. What is the suit for? Partition. Defendant number 1. You have purchased from Sanjeevappa to the sale deed. Yeah. Court held that it is the self-acquired property of Sanjeevappa, no? Because it is the self-acquired property of Sanjeevappa.
Out of 6 members have been made as a part. In that, the incident activity and modified all the family members have not been made as a part. So that time, how do I share that?
Non-joinder of necessary parties would not make the suit be dismissed on that ground. That may be perhaps the right reasoning that they have failed to prove that it is the ancestral property of the.
These are the documents. All the documents say that the
When was the sale taken place? 2012. Yes, pass over, you get your senior, otherwise you have to argue. Yes, Mr. Pujar. What is that acknowledgement you have to file? Yes. You have receipt. Which is that IA? What is not served upon you? Learned counsel for the respondent acknowledges the receipt of IA number 1 of 2020. Hence, filing of acknowledgement. You said that you have not received, right? And hence, the objections seeking to file acknowledgement in light of the order dated 11/7/2024 would not arise. Whose property is this?
If the property belongs to the plaintiff's case is that the property was purchased in the name of the defendant's father, that is the appellant's father.
Genealogy person. Where's the genealogy? Perhaps you may know, all the facts, but this court should also know, right?
Because my contention is that your lordship, that is only a self-acquired property of my father. So, and he was purchased in the year.
Genealogy bunny. Akama is one, Akama on the page 52 nalli you have given a genealogy tree. Yes.
Ningappa died intestate.
Yes.
My contention is that your lordship, the plaintiff's contention is that.
Who is the plaintiff in this? Who is the plaintiff in herein?
Your lordship.
From which branch? Chinnappa's branch or Rangapa's branch?
The plaintiff is a Chinnappa branch, first son.
Bomappa.
Bomappa
Is the plaintiff.
Plaintiff.
And then his children are respondent number
First
one.
One is his children. The plaintiff, that is the first, second respondent is his children. Now
they have filed suit against whom?
They filed the suit against the son of Rangappa, that is a Chinnappa.
His son was also Chinnappa. Defendant number one. Yes. So the dispute
Now,
is
Mama
built
is no more for that reasons his legal representatives were unreturned.
of plaintiff suit is for partition and separate.
Separate possession. In respect to the survey number 118.
Yes.
Your lordship. Their contention is that the survey number 118 was purchased in the name of Rangappa. So out of the joint family nuclear property, for that reasons, they have the share in that property. The defendant's case, appellant's case is that your lordship 118 was purchased in the year 1942 by the Rangappa, which is a self-acquired property of the Rangappa, that is the father of the appellant here. On 4/5/1942, the same offer. Out of that total 9 acres 33 meters, he sold the 3 acres, Rangappa, and balance is in possession. Earlier in the year 1960.
What is the extent of land? Only one survey number they are seeking for partition?
Only one survey number.
181 bar P.
118.
Here it is mentioned as 181 bar P.
Page 51.
Ah.
The suit schedule.
Yes, what is the suit schedule?
Agricultural land bearing survey number 181 bar P. measuring 6 acres.
118 ಅಂತ ಹೇಳಿದ್ರ. You said 118. 181 ತಾನೆ? Scheduled property.
Scheduled property. Only one property.
No other family property.
No other property.
What was your avocation? What was your father's avocation?
He was agriculture. He was agriculture. In the 1934 itself, both Chinnappa and Rangappa, who were separated from the family because no family properties were there, whatever the movable properties were there, both were divided among themselves. After that, he is doing the coolie and other works. He was purchased the Rangappa. My father was purchased the suit property on 4/5/1942. It is in the name of the Rangappa. After the death of the Rangappa, same was the revenue entries were transferred in the name of the appellant, dependent. My contention is that your lordship now we find the suit. The said that your lordship Rangappa was passed away on 7/12/1997. After his death, now the event. Your lordship, prior to that, kindly take out the additional document, your lordship. It is the history because of the taking of the lack of knowledge of the dependents. They suppressed this aspect.
What is that additional
Usually,
document?
your lordship, the very same, the Chinnappa, who is the father of the dependent, filed the suit, filed partition suit against my father Rangappa. In the year 1983, 2/39 of 1983. On the same ground is that the same was the joint family property out of the joint family fund.
Same property. Same.
property.
Then what happened? That suit. What happened to that suit?
That is dismissed, holding that that is not a joint family property, that is exclusive property of the Rangappa. Against that judgment, your lordship, the woman preferred RA. 13 of 1987. The same is also dismissed in the year 1992. Against that order, the woman prefer RSA before this honorable court. In the year 1998, the said RSA is also dismissed, confirming that and holding that the suit property is a Rangappa's property. In the admission stage itself. Then after the death of the Rangappa, after lapse of almost 7 years, in the year 2011, once again, the very same Bommappa preferred the suit against the children of the Rangappa, that is appellant hearing.
What is the substantial question of now? Why was this documents not produced by you?
This is not aware about that because Rangappa is not, because here the appellant is a small child on that day, so he is not aware about that proceedings. Taking advantage of the same, the very same Bommappa, knowing the said fact is that all the other proceedings, seeking very same prayer for the partition, against the same schedule, he only prefer that.
We will admit this appeal. Please.
Only after filing of this only we came to know about all this. We bring the
additional documents also. Whether the courts below were justified in decreeing the suit of the plaintiff, granting half share in the suit scheduled property. whether the additional documents, whether the application, whether the application I number 1 of 2024 seeking to produce the certified copy of the judgment in OS 239 of 1983, dated 21/7/1987, comma, in RA 13 of 1987 and in RSA 730 of 2009 of 1992 is required to consider for adjudication of the appeal on merits. Whether the documents sought to be produced by the appellants in I number 1 of 2024 would make the present suit hit by principles of res judicata. Admit. Admit. TCR ಬಂದಿದೆ. Admit call for TCR. I1 of 2024 to be heard along with the main appeal. Heard I1 of 2017. The drawing of final decree proceeding is stayed pending consideration of this appeal.
Number 5.
I am appearing for the caveat in this case.
Pass over.
My lord, may I seek for adjournment, my lord. I am not having file mark.
Who is
I am for the caveat. I am for the caveat, respondent number 1, my lord.
The admission is between the court and the appellant. We will see if they make out a case, we will admit. If they don't make out a case, we will dismiss. Yes.
Since my lord, I have shifted my office from Bangalore to Dharwad, my lord. Meanwhile, I have lost my file.
Who has moved this appeal? You have moved. What? Any urgency in this appeal? They have got urgency. Let us see.
Please, ma'am.
Yes, Mr. Oh. What happened? Your client, where is your client? 6 months. What is the extent of land? What is the then
But let him say what is the rate, otherwise.
is what is the rent you will have? Because if you want till 6 months, if you don't want, then we will come. Then you want to stay in the property, you want to stay in the property free of rent. 1,000 rupees, so 12 rupees from when? 1905. Alva, Mr. Prakash.
Tenancy, I understand. But then, my lord, there is no question of buying, my lord, asking for 1,000. My lord, this is which I have purchased and I put a construction. It is not, my lord, ordinary tenancy. Anyway, my lord, for want of, my lord, the original copy of the permanent tenancy granted prior to 1896. But this is my possession. But anyway, my lord, my client.
Where is your client? Who is your client? Both are standing together. Both are standing together. It means they are in good terms. They must have had a coffee and come together, right? What is some? See, you're staying in the property.
Especially, consider, my lord,
Sit across. Both have come here. Sit across now. Talk and then come back.
I pay 3,000. I filed my undertaking. My lord, I quit immediately after 3 years. I file
Not 3 years. They have not even accepted 3 years.
No, like what
They have accepted 3 years. You have accepted.
Made is
beyond 6 months, my lord, he said, I have to pay him. That is what the submission.
So till 6 months, pay some amount. After 6 months, pay some amount.
That is not, sorry, not meaning this. He has received notice from the corporation to pay the taxes. But there is a tax penalty. That can be reasonable. His will not pay for damages when the user documentation that he's paying. I don't want to take advantage. Since I am there with the construction put up by me, and I am running, I have to give up my business also. I cannot run it elsewhere in the city.
What is the business you are carrying out there? It's a factory now. What is it? It's a shed. It's a shed. Shed, alva. What is that you have put? Then that can be established anywhere. ಅಷ್ಟು ಜಾಗದಲ್ಲಿ ಬೇಕಾ ನಿಮ್ಗೆ ಎಷ್ಟು ಫೋಟೋ ಫ್ರೇಮ್ ಹಾಕ್ಲಿಕ್ಕೆ 2000 what is the square feet?
Not to the road, very small. And it's a very length is, I can't make use of whatever property.
You take some time, pay some reasonable amount, vacate the premises.
I will talk to my friend.
Talk and come back. Pass over. Talk and come back. 2:30.
Number 7, Badrinath asked.
Yes, Mr. Badrinath. What happened to your foot?
I'm not going to return shipping, no class examination, no document. Subsequent come to conclusion that based on the documents of contains of the definitive before the appeal is heard.
Your suit was partly decreed. Partly decreed. You are not aggrieved by non-granting of share in this. So you are satisfied with whatever by the trial court. First appellate court appeal was preferred by the defendant insofar as granting shares to you. How many items were there?
There are 10 items are there.
So
Except item number 3, except items are amended.
So you were given 1/11 share. And what is the reason of the first appellate court to reverse the judgment?
P2 is already a partition. They admit that in their first appellate court, the plaintiff is not a party to the P2.
So in light of a partition effected between the brothers, you are the sister? No, you are the brother.
Was in service.
Yes. What is the substantial question of now? Even in the absence of any written statement, based on the pleadings of the plaintiff, they can allow. Correct. The court has to only see what are the documents now produced by the defendants, whether they have produced any partition deed.
No evidence has been done, no.
Appeal is admitted to hear the following substantial. Whether the first appellate court was justified in reversing the judgment and decree of the trial court and dismissing the suit of the plaintiff in the absence of any written statement filed by the dependents about the partition effected between the family members. Whether the first appellate court was justified in holding that there was a partition in the family of the plaintiff and defendant, when admittedly the plaintiff is not a party to the Palupatti exhibit P2. 20/1992. Admit call for TCR. Paper book dispensed. Is heard on I-1 of 2017. Who has filed that OS? Drawing of final decree state pending consideration of the same. Drawing of final decree. Then what is that you want to stay in? That cannot be stayed. Status quo of what? Drawing of final decree. It's only state.
My lords, I appear for appeal, my lords. My lords, I have amended the cost title and filed it in the counter yesterday, my lords. Meanwhile, I seek for short accommodation, my lords.
Moot is one for what?
Partition, my lords.
Yes. And who are you?
My lords, I seek for short accommodation in this matter, my lords.
Yes. The matter is listed for admission. What is the reason for seeking adjournment?
Apologies, my lords. Senior is not keeping well, my lords. Any short date may be given, my lords.
Appellant counsel submits that amended cost title has been filed. The registry office to verify and proceed. Appellant counsel seeks time to argue the matter, stating that the appellant counsel, that is senior Santosh S. Nagarale.
Please, my lords. Grateful, my lords.
This matter next week. Date for it. 5th.
Grateful, my lords.
Vote none. Paper book dispensed. Finding of it. And now appeal is admitted to your. Yes.
Settlement, then number 9. Archandrana. Serial number 9. Archandrana.
Where is your file, madam? Where is your file? If you are a proxy, madam, we will not give you adjournment because you are coming to the court without a file. We will not accept such type of practice, madam. Then you go to civil court and make a submission. Please don't come to this court. Without file, please don't come. We will not even accept any submission of yours. No, there should be some decorum of this court, right? When you go to some function, when you go to some market, you carry the necessary things, all right? And this is a jewel of your profession. Without a file, how will you come to the court? Madam, we will not accept this. Where's the appellant counsel?
Chandrana.
Password. You come with a file, then make a proper submission.
Number 10 for dismissal, Mr. HM.
Yes, we have to invite you, Mr. Muralidhar. Nobody mentioned this. They should have mentioned it, right? In light of the appearance of the appellant counsel, the order of dismissal not arise. Yes. What is the suit for? Partly decreed for refund of earnest money.
For refund of the advance amount together with the interest. Agreement is clear. And the defense before the trial court was done. He had entered into another agreement with the second defendant on 3/1/2006. agreement with me was on 28/4/2006.
28.
4/2006, exhibit B1.
So after the earlier agreement, this agreement was executed in your favor.
See, now exhibit B1 agreement is true. So the first defendant seller entered appearance and disputed that agreement. I have proved that agreement. So in his written statement, what he stated was on 6/1/2006, I had entered into an agreement to sell with the second defendant, and I sold the property to him on 6/1/2006. That was it. The agreement which he claimed is not proved. It is proved to be a fake agreement. That is 3/1/2006 agreement produced as exhibit B1 is proved to be a fake. My respectful submission is he has admittedly sold the property to second defendant on 1/6/2006 after agreeing to sell the property to me by signing an agreement on 28/4/2006.
Is the registered sale deed executed now in favor of defendant number 2?
Yes.
Is there a registered sale deed?
Yes.
On 6/2006?
Yes. And the sale is totally viewed by them.
Who is defendant number 2? Any relation or no? Third party? No relation between defendants 1 and 2.
Defendant 1 and 2 are the cousin brothers. And plaintiff is also a distinct relative of the first and second defendant.
All are related.
Related. And my property is situated adjacent to the other property. I am the owner of survey number 96/3. And the property which I intended to purchase is 96/1, a piece of land. And see, the trial court has held that agreement is good, but since the property is sold to the second defendant, I am not entitled to this. And in the circumstance, compensation is the adequate compensation.
When was the agreement? When did you file a suit?
Suit was filed on immediately. I filed on 7/7/2006.
2006.
Yes.
2011. 3 number.
2006.
What was the time frame in the agreement?
Within 3 months, and after getting the bifurcation done in the RTC. In the RTC, the land measuring 2 acre 10 guntams is standing in the name of 2 brothers, that is defendant number 1 and his brother. The agreement was that soon it is bifurcated, I will register the agreement. Thank you. And he.
But now there is a discretion exercised by the trial court and the first appellate court.
Yes.
Discretion.
First appellate court dismissed my appeal on entirely different ground. Respectful, the substantial question of law or consideration of my laws is when once the plaintiff proves the agreement for sale and also disproves the agreement said to have been executed by defendant number 1 and 1 in favor of defendant number 2, denying the relief of specific performance is correct or not. Secondly, the reason assigned by the trial court is that they are the relatives. Anyway, the sale deed is executed. Therefore, the plaintiff cannot be given the specific performance suit. All right, I agree with that. Discretion can be exercised by the trial court provided the first defendant enters the court with clean hands. He would have entered the court saying that yes, I executed agreement in favor of the plaintiff, but later I changed my mind. I discussed the matter with the family members and sold this property to the second defendant, who is none other than the cousin brother. He did not do that. He, on the other hand, creates an agreement, antedated agreement, and disputes my agreement. Therefore, he is not a person who can be considered as a person who entered the court with clean hands. But the trial court has arbitrarily exercised the discretionary power and with a refused my client for specific performance. See, he should go before the court with that plea, right, royally. He creates an agreement antedated for a lesser sale consideration. In my agreement, 2,60,045,000 is the sale price. In his agreement, 1,15,000 is the sale price. And he disputes every single signature on exhibit P1. That is my agreement.
What was the reason for entering into an agreement of sale with you? What was the reason for agreement?
The outright sale, that's all.
He did not, he wanted any financial assistance or any, he wanted to sell the
In
property.
fact, this is out of court. He offered me to refund my money along with interest before I filed this suit. I said, no, I have not given this to take my interest from you. Look here, I am the owner of the business. Therefore, the first defendant conduct itself disentitles him any relief.
Yes, Mr. Counsel. The appeal has to be.
The agreement is very clear. The agreement says that there is no time limitation. First of one company,
But then he has approached the court in time. See, the agreement is of the year 2006. Within 3 months, he has approached the court. That is on August 7, July.
Yes.
No time limit.
They say that the agreement has to be speeded. All the circumstances, and it cannot be speeded until the partition is done. Something is happened between logic. The person how many purchase property from you by way of the world by
When the agreement of sale is held to be proved by the trial court and the first appellate court, what was the reason used specific performance, and also when it holds that the agreement in your favor, defendant number 1 has not entered into an agreement of sale in favor of defendant number 2. So both the one is in their favor, in the favor of the plaintiff, and one is in against you itself. Then where was the question of execution of this sale? So discretion exercise by the trial court and the first appellate court on the face of it appears to be arbitrary.
It was a come to conclusion that there is no notice of the instruction to the subsequent.
Correct. Now see, your agreement is dated according to you 6/1/2006, and their agreement is dated 28/4/2006. And the court, trial court and the first appellate court believes exhibit P1 but disbelieves your agreement. And where was the necessity for the trial court and the first appellate court to consider that the sale deed has been executed in your favor? Alva, so let us admit and then let us see at the time of final hearing. Admitted, huh? Oh, it is the final hearing. So what is the substantial question of law here? So having given this opinion now, you have to, yes. So the discretion exercise is not proper now in this case. What is the extent of land? Micro 5 contracts.
Sold to, agreed to sell and sold house. Another 500 will retain.
You sit across and settle. Sit across. Sit across and settle the matter. Now that defendant number 2, you're the purchaser, right? From defendant number 1. And he is an agreement holder. Agreement is held to be proved in his favor. The discretion which is exercised according to this court is arbitrary. Now, if you set aside this order, they'll be entitled for specific performance. You have to come forward. You have to come forward and execute a sale deed in their favor. Both the parties to explore the possibilities of settlement, to report settlement if any. This matter on 5th. 5th. Yeah. Yes. Yes. Yes, Mr. Vasan. Mr. Vasan. Now the will is executed in favor of whom? In favor of defendant number 7. But now the substantial question of law. Kindly come to the substantial question of law. We have to reframe the substantial question of law. Have we got the substantial question of law? No, illegal. By this court. This court said whether the lower appellate court is justified in modifying the judgment and decree passed by the trial court awarding 1/7 share out of 1/4 share of first respondent's husband. It is not first respondent's husband. Defendants is defendants. Because it's Krishnaya's property. It cannot first respondent's husband andre, she is your mother, Kannamma. Plaintiff. That would not be proper. It should be defended. And then the second substantial question of law, whether the will dated so and so executed by first defendant in favor of second defendant. 7. So this also has to be corrected. So that is why we wanted him to speak. Please pass over. 2:30, otherwise we'll do. Ask him to come. Because we have to correct this substantial. 2:30.
Final hearing. Mohan Kumar T.
Yes, Mr. Mohan Kumar. In both the matters, you have filed memo. This memo is filed by the appellants, stating that appellant number 1 to 4 are the legal and respondents 2 to 4 are the legal heirs of deceased appellant number 5. Their memo is taken on record. Appellants 1 to 4 and respondents 2 to 4 are treated as legal heirs of appellant number 5. Appellant to carry out amendment forthwith. Next matter, connected Nulli 97 Nulli, order in RSA 927. Yes. Appellant counsel has filed memo to treat respondent number 1 to 4 as legal heir of deceased respondent number 8. Memo is taken on record. Respondent number 1 to 4 are treated as a loss of respondent number 8. Yes. Appellant to carry out memo amendment and forthwith. Yes. Ah. Formally, this also would be admitted. Now, what is this? Give us the genealogy here. Where's the genealogy? Partition suit ನಲ್ಲಿ genealogy ಇಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ ಪ್ರಕಾರ genealogy ಹೇಳ್ಬಿಡಿ. What is the relationship?
First wife, as well as
Who is the original propositors? Patel Singh Gowda, no?
But second appeal, my lord, is filed by me, my lord. So my appeal, my lord, is by my lord. Yes, Lord.
But his appeal is not yet admitted. But then this appeal is admitted. So both are the plaintiffs and the defendants here. Same suit, then.
My appeal, my lord, is the suit, my lord, in entirety.
Either we have to dismiss their appeal or allow their appeal. Now, just tell what is Patel Singh Gowda? How many children he had?
The first exponent here in the is the first wife of daughter first. The first exponent here.
What is Singh Gowda's wife's name? Nanjamma.
Lakshmama and Jaykumar. Lakshmama, my lord, is the first wife.
He had two wives. Huh? What is the name?
Lakshmama is the first wife.
Huh.
Jaykumar, my lord, is the second wife. Lakshmama's daughter Sushila filed suit for partition. But once she has been social,
Lakshmama filed a suit for partition.
Lakshmama's daughter.
What is it? Only one daughter?
Only.
What is her name?
Sushila.
Sushila. She filed a suit for?
It is part of our partition.
She is the plaintiff. Okay. And now, you are the defendant.
I will defend. I will defend.
Defendants, children of Jaikumari.
And also here the defendant number 8. Jaikumari is defendant number 8. And defendant number 1 is the father, and the rest are not the
defendant number? Jaikumari is defendant number 8. And what about defendants 1 to 7? Who are they?
1 my lord is the father.
That is Patel Singh Gowda, no?
2 to 7 my lord, the children of second wife.
2 to 7 are the children of Jaikumari. Their children.
This is
Suit of the plaintiff was dismissed on the ground of
not entitled for
during the lifetime of their father.
Also, not entitled for
Suit properties are the self-acquired properties of Singh Gowda, na? ಅಂತ ನೀವು ಹೇಳ್ತೀರಾ?
Some properties are self-acquired. Lord, the entire some of the parties, Singh Gowda and others are parties. Lord, by virtue of Millard's 80, he has acquired some of the parties from his brother. He has purchased it from some portion. Other portions he has not acquired. Not through in Millard's. That's one. The other Millards on the ground floor that he not entitled to also he cannot be done. As the date of filing of suit,
That shows the these properties were acquired in the side. And who was this? And
She is the daughter of Lakshmama, who is the first wife. Jai Kumari is the second wife. Jai Kumari is she married during the lifetime of Lakshmama. Lakshmama, when Lakshmama was alive, Jai Kumari married. So then what happens to the status of defendants number 2 to 7 then?
2 to 7 may not pertain more shares in
And you are aggrieved by non-granting of share.
No, it comes to father also is talking about.
The Patel also is before this court. And defendant number 2, defendant number 3.
There is a son and the daughter of the president. The first of the court modified granted in favor of option. Now option do not have been granted. But in part. Particular code, my lord, and the option, the set of item number 1 to 3, 5 to 9, and 13 to 16.
Then why is defendant number 1 before this court now?
My lord, in respect of item number 1 to 3, 5 to 9, and 13 to 16, the option has been granted to daughter. So, in respect of self-control property, my lord, there is consent right.
Lakshmama is not alive right now. Dead.
But the second one is no.
Jai Kumari is no more. So, the daughter, the children of this Patel Singh Bola from his second wife, defendant number 2 to 7, would get share in the share that would be allotted to Patel Shinge Gowda. First, there has to be a partition between Sushila and Patel Shinge Gowda. They both will get half share. And in the half share of Patel Shinge Gowda, this defendants 2 to 7 would get the notional partition. Yes, in light of the judgment of the apex court in the case of is that illegitimate children. Sushila Mana, what is it? Revana Siddhappa. So you will be getting notional partition.
The plan of my lord half share.
Yes, half share hange baroda ಅವ್ರಿಗೆ. ಯಾಕೆ? It is a self-acquired property. Now this is the property, ancestral property. Lifetime of the father in the self-acquired property, baroda. But in the ancestral property, they are entitled. You said that the joint possession barodila. That is not the criteria now. When she is born, when the father dies, that is not. You don't dispute that she is your daughter. So the properties are the joint family properties. When there is a joint family properties, there has to be a partition between the father and the daughter. They should be given one share, and then in the share of the father, the other children would be entitled. Hello. Only if it is a self-acquired property. Idರಲ್ಲಿ self-acquired ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. Which are those items?
the item number 7, 10, 11 and 12.
And that has not been granted. Ad kotte illa. So what has been granted is in the joint family. Alva. What is the reasoning of the first appellate court?
Supreme Court says that the constitutional father has admitted that there are some properties are ancestral property. So other than because of this is an admission, so those properties are the representative.
The reasoning would come to the first appellate court order. Now they are aggrieved by non-granting of share. Huh? The point number 1 and 2 of the first appellate court. Page number 16.
Properties. Father. All these properties are not real properties. Some properties are personal. First dependent who was examined as a petition. Item number 1 to 3, 29, 3 and the 60.
He has admitted that it is. So there she is entitled for share. Okay.
So rest of the properties may not what has happened, he has produced the sale deed, 2 sale deeds and also acquired by a.
What was his avocation? What was the avocation of dependent amount? So these were the ancestral properties which he was cultivating, Alva. Apart from this, did he have any other source of income for him to acquire? Yes. So this item number 4 and 11, which are the suit properties purchased from his brother, it is from the income of this agriculture lands. See, first thing is presumption is that there is a Hindu joint family, and presumption is on the person and the burden is on him to prove that it is a joint family property. And once that the presumption is discharged, that there are sufficient income from the agriculture sources or of the income of the family, the burden shifts on you. You had to establish that there was an independent source of income for you to purchase the property. What is that independent source of income? Was it sufficient for him to purchase this property apart from the income which he had from the agriculture property of the joint family? That goes away. Yes, next. So 4 and 11 also.
Another 2
Darkas Sandrano, this is the property which was standing in the name of his father. What was that Darkas? What was he, the Inam land or something like that? What was it? Before him, who was in occupation? Say this Darkas land and all, suddenly possession like Baralavra. There would be a possession, unauthorized possession since many years. Before him, his father. This unauthorized occupation would not suddenly come in his name. It would be continued for a long period. Yes, when was that Darkhast granted? 52. What was his age? What was his age?
18 to 19 years.
18 years, 19 years. Before him, his father would have been definitely there. Next. Next. Yes. LCR Bandilma. It will be there in the final. It is available. Next. Odi. ಅಲ್ಲ ಈಗ ಎಷ್ಟೆಲ್ಲ ಮಾಡಿದ್ರಲ್ಲ ಆಯ್ತು ಈಗ ಈಗ ಇದರಲ್ಲಿ ಏನಿದೆ ಸಿ in so far as non-granting of share they have come. In so far as granting of share, now this court said to you that already it has been held as the ancestral property. There are documents to show that it is the ancestral property. And ancestral property. ಅಲ್ಲ pleading ಇಲ್ಲ ಅಂದ್ರೆ suit ಅನ್ನ ಹಾಕ್ತಾರೆ. Suit is saying that that is the ancestral property. Ancestral property ಅಂತ ಹೇಳಿ she's comfortable. Initially suit was dismissed alva. Said concurrently it has held. Yes. The concurrent findings in so far as self-acquired. Did the court say it is the self-acquired property of yours? First trial court. Trial court. There is such evidence to that. Exhibit source on that issue. Odi adana. Yes. The connected appeal is in so far as non-granting of share in that item number 4 to 4 and 11.
I'm saying,
if we correct, we will hear that for admission itself in the very stage only. We will not list it for admission. We will hear this both appeal together only. If this court finds that they are entitled, then we will frame a substantial question of law and allow the appeal. If the court feels that they are not entitled, then we'll dismiss the appeal on the stage of admission itself. We'll make a specific note of it. Or the appellant counsel in part in RSA 292 of 2016 to hear further. This is the matter for further hearing on. We will forget, Mr. Counsel. See, when the court wants to hear the appeal, you all take adjournment. What is this? Then what is that you're making? Fourth we said. Fourth. Seventh. Twelfth. Further hearing. 1 minute. Just a moment, kindly be seated. Yes.
Okay.
This is a substantial question of law.
The Procedural showed house without findings and evidence of record. It is good for partition grants shares value part. So despite there being a clear admission on the other side that he separated from the family very well in a secret manner. And then he releases all his rights in 1940. Then the remaining brothers who still continue to be in the joint family, they divide the property. This is partition equal. And this affected. 1960 after 40 years. All these properties are self-afford properties. So you can say the high father acquired all these properties. Substantial question of the. That the Procedural court without having any pleading or evidence on record would have granted a relief for partition, despite clear admission by the plaintiffs that the.
Now, this is the substantial question of law which is already framed by this court. Whether the first appellate court is justified in granting a decree of partition without noticing the sale deed. Without noticing the sale deed in favor of the. So we will hear you and then we will see whether it is necessary. Yes. What is, you are the defendant? First defendant. How many defendants are there?
Defendants, I would say to take your orders to please no paper. Seven defendants.
Relationship between the plaintiff. Not a dispute. And who are they? Plaintiff is the brush.
But you see that very critically stated in the plaintiff's para 2, page 4. Common ancestor is Ruhoya. He had 5 sons. Para 2.
He had how many children?
5 sons. Gotwailappa, who is the father of the plaintiffs, the brothers, 2 brothers. And the second one is MP Nanjappa.
Nanjappa.
Sure. Not to find it para 2.
And then
And then
Chandrana.
the third one, MP Chandrana.
And Malaya.
And MP Chandraya. MP Ikkabaila. And the last of the sons is MP Malaya.
And this Malaya. And the plaintiffs are the children of?
Plaintiffs are sons of the son.
Plaintiff number 1 and plaintiff number 2.
And the mother of these, he died earlier, and Proboya did not explain anything.
No will.
He died in this.
And who are the defendants here?
Defendants are the sons of the other MP Nanjapnavara, the Yashidaraya.
Nanjappan Makla. How many? All the defendants are Nanjappa's children?
Defendant number 1, 2, what is the record?
And then Chandrana? Defendant number 1 and 2 are the children of Nanjappa.
3, 1, 2, 3. And Chandra in our Maklu record 4A, 4B, 4C.
Chandrana was a party. Defendant number 4 was a party. He was defendant number 4, huh? Manjappa was also a party, no? Manjappa was also a party.
What is the right? How record number? Shidaraya and Vanchakshara of the sons. Japa was not.
Not a party. So dependent's children, dependent number 4 was Chandranna, na? Chandraya.
ಆಮೇಲೆ ಅವರು ತೀರ್ಕೊಂಡ್ಮೇಲೆ ಅವರ ಗಿರಿಜಮ್ಮ
That is dependent number 4, A, B, and C.
A, B, C, D, E, F, D. ಅವರೆಲ್ಲ ಚಂದ್ರಯ್ಯ ಬರ್ತಾರೆ.
And Chikkabailappa ಮಕ್ಕಳು?
ಚಿಕ್ಕಬೈಲಪ್ಪ
He also was a party, dependent number 5. Then he died. Then he also died.
5A, 5B, 5C, 5D.
So Mallaya ಮಕ್ಕಳು? Mallaya is alive. He is dependent number 6. He is dependent number 7. Who is it? Chandraya, and the third son. Dependent number 7.
Trading celebrates the suit for declaration. They claimed all these institutional property. Can you take to page 10 of the claim of the paperwork? They are all situated in one block according to the claimants. Survey number 1, 2, 3, 4, 7, 8, 9, 10, 11, 12. Of course, the measurements are given. And they are all bounded by common boundary. The plaintiff claim it belonged to our father. It was a self-acquisition.
Dodda Ballappa, Bailappa.
Then straight away I will take your lordship to the para number 4 of the claim.
Declaration and injunction, huh?
Declaration is declaration. Allah, possession of credit. They say lost possession. The lordship finds it on page 10, the clear column. Declaring that the plaintiffs are the absolute owners of the scheduled properties. And the second prayer is direct the defendants to deliver possession of the scheduled properties to the plaintiff. And then third prayer is declare the partition dated 1/1967 as not binding. Very conspicuous thing is 1942 document is an admitted document because of the evidence, a registered partition deed amongst the other sons of Goya. That document is not put to challenge. So they admit that 1948.
This plaintiff was a party.
Release.
The plaintiff was a party.
Plaintiff was not a party because kindly take to page 6. He himself says that I got separated in 1939. Para 4.
What is the averment in the plaint?
Plain averment is all the suited properties from that agreement. And the source for such acquisition, the lordship finds it at page 5 of the paper. According to that.
Self-acquired property of Dodda Bailappa.
According to that, first 3 lines, of course, very hazy and there's no clarity in so far as the source of title to the property as acquired by Lappa as they claim. Apart from the properties left by Gogoya, his son Dodda Lappa acquired some properties on his own. The properties acquired by Dodda Lappa 1 to 7, survey number 1 to 7, 11 to 12, situated only at that of the scheduled property. Then, out of the scheduled properties, survey number 2 and 9 to 12 have been granted to Dodda Lappa as per the order of the subdivision of the on 8/4/1989 and issued Hangami Sarvati. So, for as properties bearing survey number 3, 4, 7, and 8. Said the Bailappa had paid the entire land revenue at the time of auction of the land for land revenue deed as per the order of land granted to us. And Tata has been entered in it. So this is the ground for the plaintiff to assert that it was a self-execution of Gurbaila. Not a scrap of paper is produced to show that Gurbaila did. All these documents were the revenue documents was released to the Gurbaila, not that I come to say. Then kindly take to para 4.
So according to you, this was not standing in the name of Dodda Bailappa, but was standing in the name of Prabhu. So then if it is standing in the name of Prabhu, the plaintiffs and the other defendants would be entitled for share. Is it right?
Correct. Later the trade government is here, but separated in 1930, that is the trade government. Para 4. That is the Para 4, page 6 of the paper book. Gurbaila, who is the father, when he started to be separately from his brother from 1935. It's an undisputed fact. He himself would state that I got separated from my brothers by taking his share out of the ancestral property belonging to the family. It is Gurbaila has executed a release in the 1948, releasing his rights in the joint family ancestral property by accepting his share. We have produced then there is also a reference.
The partition deed was executed in the year 1939 itself?
No, partition deed in 1967 amongst after the release date. 1948 is the release date. The brothers would keep themselves intact in 1967. 1967 they themselves divided into substitute properties. Yes. Thereafter, the revenue entries are also made.
Yes.
On the basis of the partition deed. The state government would further state that because an issue of regarding limitation also raised by the defendants rightly so. The state government would say, when did he come to know about this 1948 document? Para 6 state.
Yes.
Page 8, para 6 of the paper book.
Yes.
On the strength of the mutation and RTC entries which came to the knowledge of the plaintiff by 1996. So then you would rush to 1996, and then he approaches the Tahsildar and the Tahsildar would say, as it usually happens, this is a civil case involved resolved with the civil court. So, again, our cause of action, para 8, page 9 of the paper book, they say it is July 1996.
Yes.
And in para 9, and it would further disband insofar as the joint status. There the relief sought in this is for declaration of title and for delivery of possession. They did not say when did they do this.
Yes.
So one that's an admitted thing that they knew about 1939 separation, 1948 release deed, 1967 partition deed, the revenue entries in 1996, the cause of action, Yellow Charman case, and clear admission that they are no possession. So that is the second prayer would clearly further would see the case, seeking delivery of possession. Okay.
Yes.
And the trial court, of course, rightly so, clearly held that the plaintiffs knew that what had happened about all these decades together, having got separated in 1939, 1948 release deed, the revenue entries, then the partition, separate, rightly dismissed. But the first appellate court stretches itself to a certain extent beyond this jurisdiction. There is no pleading for partition. Since the original record stood in the name of proprietor, since this relationship is not disputed amongst the parties, the five sons, the first appellate thought it, right, that now this property should be simply divided. That is the operative portion. With respect of the value of the set aside, last paragraph, number, the suit of the plaintiff is decreed, declaring that the suit of the property, the ancestral joint family property, the plaintiff's father and his brother and both brothers by name Nanjaba Chandra, and it's declared that each of them shall be entitled for 1/5 share in the suitable properties. Consequently, respective branches divided amongst themselves to be worked out in a manner. So this is the point.
How did the first appellate court proceed with the partition and 1939 and the
Now, before that, may I request your lordships to take to 343. These were the issues framed by the trial court. And 7 issues. Since they sought declaration that they should be declared as the owners, the first issue was heavily cast upon them. Whether the plaintiffs prove that they are the absolute owners and in possession of the suitable properties. Whether the fifth defendant proves that already there is a partition on 3/5/1967 as contended in the history. Then whether the suit is maintained in respect to fair relief D, because there are some directions sought as against revenue authorities. Then whether plaintiffs defendant number 5 and 4 prove that suit is barred by limitation. Of course, there's a clear finding by the trial court in so far as particular issue is concerned, which was answered in the affirmative. Whether defendants will prove that this court has no jurisdiction, of course, I will not harp upon much because the court did have the jurisdiction. Then whether the plaintiff is entitled, then kindly take to the reasoning of the first appellate court. Para 26 of 353, take to 353. The first appellate court thought it right to frame these points for its consideration. Whether the plaintiff is entitled to summoning of documents or not, don't do. Whether issue number 7, year number 7 is entitled from because in some impleading application, and then whether the plaintiffs the appellants prove that the additional issues are required to be framed on paragraph 4 and 6, and then 7 and 8 of the written statement. And then whether the appellant or plaintiffs had two dissociated properties or the absolute properties, of course, that again it relates to the issue number 1, property, absolute properties of the father, and the plaintiff is entitled for declaration consequence. Whether the plaintiffs prove that the judgment and decree is favored suspicious against the facts, and all these, all the reasoning given is Then kindly take to the reasoning why the prior court's order was upset by the first appellate 516. Then your lordship finds it at 364.
Yes.
The points 516. Then I would not read because these are undisputed facts so relationships are concerned. And then kindly take to page 41 first, because these are the repetitions of the pleadings by the parties. Kindly take to 367 para number 41. On the basis of the aforesaid pleadings, it was an admitted fact and supported with document evidence also that the property that was granted by revenue authorities was sold in public auction for recovery of land revenue. It has also become an admitted fact that the said property was purchased way back by one of the brothers, that is Nanjappa, is an admitted fact, who was the member of undivided Hindu joint family having ancestral joint family properties. It is important to note that after filing of the written statement by defendant 5 and 6 and 4, the plaintiffs have not filed any rejoinder or an amendment to that text.
Yes.
Then, at this juncture, I would take your lordship's kind attention to the written statement, because there are certain things that was stated by the written statement which certainly warranted a rejoinder or an amendment from the other side. When we take to page number 13 of the paper book, para 3 of the written statement that is filed by defendant number 4P MC Ramesh. Of course, this certainly required when so much things have been said, what properties he took before the release. So this was not confronted or countered by the other side. The facts stated in para 4 that the plaintiff's father had executed the release deed dated 1/11/1948 in favor of his brothers, relinquished all his rights in the joint family properties is true and correct. The properties bearing survey number 132, an extent of 4 acres 39 guntas, 134, an extent of 5 acres 6 guntas, both properties situated at Dandiganahalli, and another property situated at Manchanhalli bearing 273/2 to an extent of 1 acre 4 guntas, and house property bearing Manchanhalli. By taking all these properties, he relinquished all the rights in the joint family. There is specific denial that what the defendants are very clear that the clarity in the written statement, what properties that Bailappa took before relinquishing. No rejoinder. The court rightly observed there is no rejoinder. And then I would revert back to.
No, they don't dispute that on 1/11/1948, there was a relinquishment by their father in favor of the brothers. Did they say anything that it was by fraud? No.
No, nothing. That's what all the 6 civil courts have been coming to courts. Absolutely no pleading that particular, because my father was an illiterate, he was an uneducated, Amayaka,
Nothing is forthcoming.
Not a whisper of misrepresentation of fraud or coercion or threat, nothing. Straight away they say 1937 ನಲ್ಲಿ ದೂರ ಆದ್ವಿ 47 ನಲ್ಲಿ Guru challenge ಮಾಡಿದ್ರು 1948 they should have put a challenge. Clear column your lordship. 1967 partition date ಮಾತ್ರ ಹೋಗಬೇಕು. The earlier document is still intact, 1948 release date. So that is unquestioned. And one thing is, I'll go one step further.
Yes.
The dismissal ಆದ್ಮೇಲೆ, after the suit was dismissed.
Yes.
The first appellate court allowed the appeal, which is now asserted before your lordship. Having categorically stated all these successional properties which are 10 or 12 in number in one block, bounded by a common boundary, ಎಲ್ಲೂ ನಮಗೆ ಬರಬೇಕು ಅಂತ ಹೇಳಿದಂತವರು they are satisfied with the partition. Of course, going one step further. If at all there was very clear about their own case, no, this is nobody's property except my developer's property. The first appellate court says, no, I am somebody, I get ಹಾಗಾಗಿ ಅದು ಆಪ್ಷನ್ ಆಗಿತ್ತು. ಆಪ್ಷನ್ ಬಗ್ಗೆ ಎಲ್ಲೂ ಸಹ ಒಂದು whisper, there is not even a whisper about the option, because all these properties way back in 1942-43, because of the land revenue due, was put to auction by the government. Somebody purchased it, and then Nanjava, one of the sons of the joint family, when he had separated himself, he purchased in 1942, and thereafter, knowing well, then he relinquishes all.
Come to the reasoning of the first objection.
Then kindly take to page 368. It's an undisputed fact that the original proposers died in the year 1929. The release deed was executed by the father of the plaintiffs in 1948 and disputed. The successional properties was repurchased by Venkat Subbegoda from Venkat Subbegoda by one of the sons, Nanjappa, in the year 1943. It is nobody's case that Hindu joint family consisting of these 5 brothers had partitioned their family properties by means of property. Even after the death of the father of the 5 brothers, joint family continued. Thereafter, it becomes an admitted fact on record that when the properties were purchased by MP Nanjappa in the year 1943, there was no partition by means and forms in the joint family. The dependents themselves have contended that those granted properties were also the ancestral joint family properties, since the grandfather of the plaintiffs, thereafter the father of the plaintiff, Karta, Prabhuvaya was the Karta, and that because he died here, the eldest son was Dharvaila. Thereafter, father of the plaintiff was the Karta of the family. Thereafter, the revenue records were standing in their names. If this is taken as an admitted fact on record, then the plain schedule properties are admittedly ancestral. It is nobody's case that MP Nanjappa acquired these properties out of his own earnings without the aid of arising of the joint family. Also an admitted fact of record by the purchase of the land. These 4 brothers got partitioned the properties and other properties. Other than the properties taken away by the father of the plaintiffs by executing the relinquishment deed in 1948. So this 1948 event was preceded by separation of 1939 by Dharvaila, having specifically stated the defendants are specifically stated in the statement. These are the properties which Dharvaila took, which has remained uncontroverted even at this stage. It would be the implication and the influence that can be drawn by this court and rightly by the trial court that they have relinquished all these rights as they did of 1940. And then I will go further. It is also an admitted fact on record that OS 85 was 1945-45 by 3 sons of Edman, Prabhuvaya, namely Chaturya, Narayan Rao, and father, the plaintiff Dharvaila. That was the proof for declaration of plaintiffs forfeit the share in the successional properties, and the judgment and decree obtained the first defendant is against towards the said court would not find the plaintiff's share was executed. This judgment is relied on by the plaintiffs as per Exhibit P34 to show that his father had separate self-acquired properties, particularly survey number 40. The reason for, and I would stop here for a minute. This particular survey number has nothing to do with joint family status restored by this property. That has no binding on the suit. Of course, the trial court also felt the same thing. This particular survey number has no bearing on the adjudication of the matter. Rightly disbelieved. Then, the reason for filing this suit was that first defendant of that suit had filed OS 470 of 1934-35 against two brothers in his father and against the father for recovery of money. The said suit was 470 of 34-34 was decreed and execution was taken. First defendant purchased the suit. The OS 85-45 46 was quite granted. Other brothers had not incurred any claim, nor there was any such. The joint family property property is incurred by the consequent exclusive questions are not valid. Therefore, each had claimed 150 years. Therefore, it is a fair admission that unpaid locally in judicial proceedings by two persons in the father of the plaintiff that they are the managers of the individual. This is one reason given by the separate. At page 11 of the judgment, it is an admitted fact that plaintiffs who are living as members of the affidavit. The judgment is dated 27/8/1946. Since the property is purchased by father of the plaintiff in the revenue sale, and in the absence of evidence that the said properties were purchased from and out of joint family, to sell the properties seconded. It was held that the decretal dating OS 470 of 34 was brought to be for the benefit of joint family and family necessity, and it was binding on the plaintiffs who were the members of the joint family then. Second defendant and second, third, as managers of the relevant family person. He succeeded for one exam. Consequently, the suit came to this. From the pleadings on record, it is clear that suits of properties were sold in a revenue auction. The divisional commissioner, before the divisional commissioner, there was one of the judgment was 25/45/46. 7/45 had to be self-acquired property his father, having purchased in the revenue sale, does not give meaning that the present possessions are also self-acquired property of the father. Therefore, on perusal of the pleading on record, it is clear that the substituted properties came back to the family before the father of the plaintiff got released year 1948. I will stop here for this reasoning. I am not certainly disagree with this. Kindly look at the sequence of events. There were certain suits. The suits of the properties were not subject matter in that 470. The dependents having particularly plead, these are the property of the first of reputation. These are the specific properties that were taken away by Zotbai Lappa for relinquishing all his rights. Of course, the relinquishment deed, I won't say that. Let me be very clear. The relinquishment deed does not disclose any other surveillance. I misquote. The old documentation. Ella nanna Pitrajito Rastigal but that straight sentence which the other minority trade certainly take advantage of, since no survey number is mentioned, that the other attendant circumstances that transferred with the family, partition, and what was his age when he acquired the property. The reasoning is mostly very tribal. He was hardly 18 years. Father died young. He was the eldest in the family. He property won't step forward. So it is not as if he is just sent out bare hand bare foot. He has been given a property which he doesn't dispute it. Partition I now. So that he wants to keep all his properties that came out from the ancestors very intact. Our ಹೆಸರು ಬಂದಿತ್ತು ಅಂತ ಒಂದೇ ಒಂದು ಕಾರಣಕ್ಕೆ ಆಪ್ಷನ್ಸ್ ಏನಲ್ಲಿ that is the only reason. None of these are not by a problem. Then I will go further. Then kindly take to the next page. Of course, even actually there are certain mistakes on the part of the first appellate courts while finding reversing the judgment of the trial. Fourth line, please, 373.
370?
373.
No.
Thus, defendant 1 to 3, or the leaders have not contended that the properties acquired by predecessor, and they were self-acquisition acquired properties acquired by the same. Defendants 5 and 6 were brothers of plaintiff's father, and then therefore does not appear to have filed a written statement. Written statement I have been answered. This is what I exactly did. That is an incorrect conclusion drawn by the cases. They did file, the lordship finds it at page 3 of the paper book. Written statement is there. I also contended after the death of everyone proposed in 1928. 5 sons continue to be in joint possession, constituted a legal joint family, and the father of the managing the families and the properties as the custom and the properties which are acquired by the family of the father. As the eldest son, distributed the properties and some other properties were made in the name of the father. Therefore, he has not acquired during his lifetime as his own. It is also not the case of the plaintiff that there was any partition. By means and bounties, all the joint family, and thereafter is their father out of his own earnings had acquired the plaintiff. If this could be the reason, because the first appellate court judge also rightly observes that it was not their pleading for partition. That is an admitted thing. And when it is an admitted fact that the said properties were sold in the revenue auction, purchased by a third party and again repurchased by one of the joint family properties, indicate that the said properties were the ancestral joint. This is the conclusion drawn by the first appellate court also rightly. And then, I think I can write in a way. Uphold a lot of that. But it is not inconvenient in the second position.
In the afternoon, after dictation matter, we will take your mind. After dictation. Who has filed power now? So who appears for 1B? No. HR Vasudha for respondent number 1. Correct. Now you are filing Wakalat, and then it was held sufficient for respondent number 1A and B. Notice was ordered. Then what was that? You should have mentioned at the first while the matter was going on. After so much of argument, is it proper on your part? No, we will not accept it now. How can we accept it now after hearing the matter? So you filed a wakalat when? You filed and now you're filing a memo of retirement stating that they have taken NOC from you. Then have you issued notice to them? Acknowledgement is also there. Who is appearing for 1A? Who is respondent number 1 anyway? Is the plaintiff number 1, huh? Respondent number 1 is plaintiff number 1. Plaintiff? Prabhuvaya. Then one is what? M.A. Ramesh. M.B. Prabhuvaya was also alive when the appeal was preferred here. Now his children only are these other children, right? Others are his children only. And these two children were not brought on to. You Madhyan Heli, let us see. We will take it up in the afternoon. Yes. 21, what happened? Who has moved this appeal? And who are you? Have you informed the appellant counsel? First inform him and then get back to the court. Yes.
Last time it was placed.
Come in the afternoon. They are objecting, Alva. Let us see. Serial number? You were not there when it was called. Where was your colleague who mentioned in the first hour? And what you come the afternoon. Agreed. And the counsel on both sides submits that the parties have amicably settled the dispute and seeks an adjournment to list the matter on 5th September. 3rd, to report settlement. List this matter on 3rd September. You file an undertaking affidavit and a joint memo by both. You file a compromise petition, then an affidavit of the appellant. Yes. That's good. You have settled the matter. Yes. To report settlement. What is that? 1-5. Yes. Yes, we have one dictation. As well. Yes, you can come. Yes. Serial number? Yes. You appear for the? Who is the appellant? Where is the appellant? Have you informed the other side? What is this sign? Can you make sign to the courts? You can't give a call to this. Is it not? Let us complete this serial number which is mentioning. Yes. At request of the respondent counsel. This matter next week. Serial number first matter. ನೀವು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾವೇನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? Yes. To Leonard counsel for the appellant seeks time to report settlement. At request list this matter on 5th. 5th. 5. 4 ಕೊಡಿ. Yes, yes. Where is he? Yes.
Date of retirement is it becomes so then 1 to 6.
So he's the apex court. We have to await. Allah, that is what madam is saying, that the dispute is pending before the apex court. Allah, Mr. Sundar Rao, our submission ಏನ್ ಮಾಡಿದ್ರಿ ಈಗ? Allah, what is your submission? So this matter is not covered with the matters which is pending before the apex court. Correct, that we have to consider, right? Is the issue pending before the apex court? ನೀವು ಯಾವ್ದಾರ ಒಂದ್ ಹೇಳ್ಬೇಕು. Is it pending? Identical issue is pending before the apex. Mr. Sundar Rao, you have been consistently mentioning before the court that the identical issue which is in this matter is pending before the apex court. Is it so? Then contention, that's all under game. Yes. We will take up this matter. Yes. We will take it up after that. List number? At request of the appellant, as a last chance, list this matter on 5th of February. Yes. 1-5. ಈಗ ಇಷ್ಟೊತ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರಲ್ಲ. Yes. Have you informed Mr. Ravi Shankar? Yes. At request of the appellant. Yes. You're for the appellant or the respondent? At request on both sides. List this matter on 5th September.
Number 1 for admission.
Yes, Mr. Yadwar. Mr. Yadwar.
Serial number 1. Please, Yadwad.
Mr. Yadwad. No network issue again.
Please, Yadwad. Could you able to hear me, sir?
Please, I am for compromise petition is ready. My lord. My lord,
So if the compromise is ready, how is it? Yes. Now that you are settling the matter, we will dismiss this review petition. You settle the matter.
My lord,
You can't file a review compromise petition in this. Mr. Counsel, what is your name? What is your name?
Sorry, my lord.
Mr. Counsel, what is your name?
Rahul Kunsoji, my lord.
Mr.
Kunsoji, my lord.
Rahul, Mr. Rahul, it was made clear to your senior that the settlement cannot be arrived in the petition. If you have settled the matter, you have to just say and we will dismiss this review petition because we have not even ordered notice. Yes, Mr. Rahul.
Kindly 2 more weeks, my lord.
No, we will not adjourn it. Ask your senior to come.
In this matter, my lord, the records are going some late, my lord, since the compromise. Kindly, but 2 more weeks, my lord, finally. Please, my lord.
No, we are not going to adjourn it. Ask your senior to come.
Lord,
Yes,
kindly,
next.
finally 2 weeks, my lord.
Yes.
Then number 14.
Yes. After the dictation matter, we will take up your matter. After the dictation.
Number 11. Dictation.
Yes. Mr. Counsel, we have to reframe the substantial question of law. Yes, there are some mistake in the. Yes, we will rectify the substantial. Kindly be seated. Defendants number 2, 3, 4, 5. And 7 are before this court. Are before this court in the regular second appeal, assailing the judgment and decree in RA 15 of 2013, dated 27/2/2016, on the file of the third additional district and session judge Ramnagara, referred to as first appellate court, and the judgment and decree dated 30th August 2012 in OS number 165 of 2004 on the file of the principal senior civil judge Ramnagara, referred to as trial court for short. This court, while admitting the appeal, has framed the following substantial question of law. On 8/8/2016. At the time of argument, this court has reframed or rectified the substantial question of law framed by this court as under whether the first appellate court is justified in modifying the judgment and decree passed by the trial court and awarding 1/7 share out of 1/4 share of Krishnaya, husband of dependent number 1. Question now. 2. Whether the will dated 2/2/2003 executed by the first dependent in favor of the 7th dependent, bequeathing the land bearing survey number 53 of Hejalla village to an extent of 3 acres, 10.5 guntas and 30 guntas is proved in accordance with law. Learned counsel for the appellant of His Sri so and so. Learned counsel for the appellant and the respondent have been heard on the reframed or rectified substantial questions of law framed by this court. Learned counsel for the appellant would urge the following grounds: that the trial court has fell in error in decreeing the suit of the plaintiff and defendant number 8, and the LRs of defendant number 6, awarding 1/8 share in the suit schedule property. That the first appellate court, you are also selling that modification also. Modification is in your favor. You are selling that also. Modification is in their favor, right? Adanu challenge ಮಾಡ್ತೀರಾ? But that is also your ground now. It's true. That the courts below have erroneously held that the plaintiff is entitled for share in suit item number 4, 6, 8 to 12, which are the exclusive properties of first defendant. But only 4 was the exclusive property, right? Only item number 4. ಅದನ್ನು ಹಂಗೆ ಹೇಳಿ. Daughters ಯಾರು? Daughters are? They were not the defendants, appellants before the first appellate court? They were. But even otherwise, how can they say so? Rangamma and defendant number 5 and 6 were the. Which are the exclusive property for the defendant number 1. That the courts below have erroneously answered additional issue in the negative, holding that the defendants have failed to prove the execution of the will in favor of the defendant number 7 by defendant number 1, without considering that the defendants have proved the execution of the will in accordance with section 63 of the Indian Succession Act and section 68 of the Indian Evidence Act 1872. Next paragraph. For contra, the learned counsel appearing for the respondent submits that the courts below have rightly held that the defendants have failed to prove the execution of the will by defendant number 1 in favor of defendant number 2, defendant number 7, and the plaintiff is entitled for share in the suit schedule properties of defendant, suit schedule properties of defendant number, entitled for share in the self-acquired property of defendant number 1 as well, who died during the pendency of the suit. It is further contended that the first appellate court have fell in error in modifying the judgment and decree of the trial court by awarding 1/7 share out of 1/4 share of Krishnaya, contrary to the settled proposition of law as declared in Vinita Sharma versus Rakesh Sharma, and the awarding of notional share needs to be modified in the present appeal by awarding equal share to the plaintiffs, though the plaintiff have not preferred appeal against the or judgment and decree of the first appellate court. Before answering the substantial question of law number 1, substantial question of law number 2 is considered by this court. Next one. Regarding substantial question number 2. Suit for partition and separate possession in respect of item number 1 to 12 of the scheduled properties. The family pedigree of the parties is as under. One Krishnaya, original proprietor, wife Minijamma, dependent number 1, your Makru, Sripati, first son, Neelamma, dependent number 6, Rangamma, dependent number 5, Shivkumar, dependent number 2, Nagendra, dependent number 3, Kantamma, dependent number 7, Prakash, dependent number 4, Sripati, Channamma, plaintiff number 1, Orginath Makru, Premalata, Girish, Premlata is dependent number 8, Girish is plaintiff number 2, Suresh is plaintiff number 3, Nagendra, plaintiff number 4. The plaintiff covers that the suit scheduled properties, ancestral joint family properties of the plaintiff and defendants, and there is no division of the joint family properties among the sons of Krishnaya. The plaintiffs are entitled for 1/5 share in the suit scheduled property. Defendant number 1, Minijamma, filed her written statement inter alia contending that item number 1 to 3 of the suit scheduled property, the plaintiffs and defendants are entitled for their legitimate right and share. However, in respect to item number 4 of the suit scheduled properties, survey number 53/1, measuring 4 acres, half guntas, according to the defendant, number 1, it is her exclusive property, having received the property by a gift from her father, Sri Puttarevaya, Puttarevaya, and a registered gift deed dated 24/6/1943, and that the item number 4 constitutes the Sridhana property and is her exclusive property, of which she is in lawful and peaceful possession and enjoyment. The defendant number 1 specifically stated that the plaintiffs and the other defendants 2 to 7 have no manner of right, title, or interest in item number 4 of the suit scheduled property. And item number 4 is not liable for partition among the plaintiffs and defendants. the prayer of the defendant in her written statement was to dispose of the suit, allotting legitimate share in item number 1 to 3 of the suit scheduled property. The written statement of the defendant number 1 filed written statement on 31/12/2004. Next para. Defendants 2, 3, and 4 filed their written statement inter alia contending that the contending that they have no objections for partition of the suit items 1 to 3, subject to the condition that the plaintiffs will pay the share of discharge of debts incurred by Krishnaya during his lifetime. And when the first defendant along, and also they will have to make provision for the expenses of the marriage of third defendant. Next. Defendant number 6 filed a written statement admitting the claim of the plaintiff and consenting for decree of the suit granting 1/8 share to the plaintiff and defendants 1 to 7 each in respect of the suit scheduled property. The defendant number 1, Minijamma, died on, when did she die? Died on dash date during the pendency of the suit. During the pendency of this, kindly give the date. 27/8/2010. The defendants 2, 3, and 4 amended the writ petition, amended the written statement, inter alia contending that the first defendant, Minijamma, has executed a will in respect of her property, item number 4, survey number 53, on 8/2/2003, to an extent of 3 acres, 10.5 guntas, and 30 guntas, 30, in favor of the 7th defendant during her lifetime. The trial court, on the basis of the pleadings, the plaintiffs filed rejoinder after the amendment of the written statement, contending that the alleged will executed by the first defendant in favor of 7th defendant is false, illegal, forged, and concocted for the purpose of the suit and to defeat the legal rights of the plaintiff from claiming their legitimate share in the suit property. And the first defendant has not executed any will as alleged by the defendants 2, 3, and 4 and sought for share in item number 4 of the suit property on death of defendant number 1. The trial court, on basis of the pleadings, framed the following issues, page number 27 of the paper. Additional. The trial court. Before the trial court, the plaintiff, number 2, examined herself as PW1, marked documents at exhibit P1 to P18. On the other hand, the defendant examined 4 witnesses as DW1 to 4 and marked documents at exhibit D1 to D23. The trial court, on basis of the pleadings and oral and documentary evidence, arrived at a conclusion that 1. That the plaintiff has proved that the suit properties are the joint family properties of the plaintiff and defendant. Which are the suit properties held to be the joint family properties, all the properties by the trial court? Item number 1 to 5. Item number 5 and 7. And the properties were held to be the defendant number 1. But then it is 3 acres per 30. The trial court, by the judgment and decree, held that item number 1 to 3, 1 and 5 and 7 are the ancestral joint family property of the plaintiff and defendant. Sarah? Item number 1 to 3, 5 to 5, 7, 8 and 10 are the ancestral joint family properties of the plaintiff and defendant. And item number 4, 6, 9, 11 and 12 are the self-acquired properties of defendant number 201. 1. Defendant number 1. Defendant number 1. Correct distance, no? 4, 6 are the self-acquired properties of defendant number 1. And in view of the death of defendant number 1 during the pendency of the appeal, the husband of plaintiff, father of the other plaintiff, husband of plaintiff and father of the other plaintiff, comma, defendant number 8 and defendant number 8, K-Shripati, husband of first plaintiff, father of plaintiffs and defendant number 8, K-Shripati, comma, defendant number 2 to 7 being the daughters and sons of Minijamma, defendant number 1 are entitled for equal share. And by the judgment and decree, the trial court decreed the suit of the plaintiffs, holding that the plaintiffs and dependent number 8 together are entitled for 1/8 share. And the loss of dependent number 6 together are entitled for 1/8 share in the suit schedule properties. Agreed. The dependent dependent number 2, 3, 4, 5, and 6 preferred appeal before the first appellate court. The first appellate court, while reappreciating and reconsidering the entire, and I will speak about 1/6 judgment and decree, and trial court to the hearing 1, 2, 3, 4. Okay. On additional issue regarding the proving of the execution of the will in respect of item number 4 in favor of the dependent number 7 by dependent number 1, the trial court observed that the trial court arrived at a conclusion that the defendants have failed to prove that dependent number 1 has executed will dated 8/2/2003 in favor of dependent number 7. And the evidence placed by the defendants themselves creates suspicious circumstances, and answered additional issue in the negative. And by the judgment and decree, aggrieved the defendants preferred appeal before the first appellate court. The first appellate court, while reappreciating and reconsidering the entire oral and documentary evidence, confirmed the findings recorded by the trial court on additional issue and held that the defendants 2, 3, and 4 have failed to establish the execution of will by dependent number 1 in favor of dependent number 7 in respect of item number 4. While confirming the judgment and decree of the first appellate court in regard to the findings on additional issue, the first appellate court modified the awarding of shares to the plaintiffs and defendants by placing reliance on the decision of the apex court in the case of Prakash versus Pulavati, as the law prevailed at that point of time, and held that the plaintiffs 2 to 4 and defendant number 8 together are entitled for 1/7 share out of the 1/4 share allotted to Krishnaya in item number 1, 2, 3, 5, and 7 of the schedule. And 1/7 share in item number 4, 6, 8 to 12 of the schedule. The defendant number 7 did not file any written statement. She is the propounder. She did not file any returns. She filed. She doesn't amend the return statement. Dependent number 6 or dependent number 7 now.
7.
Dependent number 7 is Kantamma. And then this return statement is filed by dependent number 6. 7 haklipa. Paper book it is doesn't appear to be there. Record study. And who are the LRs of dependent number 6? Yaar Dependent number 6 is Neelamma. She is the daughter of Krishnaya. Dependent number 7 is Kantamma. So she has not filed any returns there. The same contention of dependent number 2 and 3. So 4 is not filed. It's only 7. So now dependents 2 and 3 and 3 and 4. No, but then it has been corrected as 7 here. It has been corrected as 7.
Last evening, the first modified the judgment and decree awarding no share to the plaintiff and defendant by placing reliance on the decision of the others.
Additional issue framed by the trial committee, which has under. The burden was on the defendants 2 to 5 and 7 to prove that the first defendant has executed a will in respect of item number 4 on 8/2/2003, conferring right in respect of item number 4 in favor of defendant number 7. The report, while considering the validity and execution of the will, the following principle is required for proving the will. It is enumerated as under. Case number Veena Pradhan. Roman 1, 3 Roman 9. The statutory compliance is that the testator has signed the will out of her own free will. 2, that at the time of execution, she was in a sound state of mind. 3, and she was aware of the nature and effect thereof. 4, and the will was not executed under any suspicious circumstance. The will said to be executed in favor of seventh defendant is by defendant number 1, who had filed her written statement on 31/12/2004. And in her written statement, she specifically contended that neither the plaintiffs nor the other defendants are entitled for any manner of right, title, or interest in item number 4 of the suit scheduled property, which is her exclusive property. The written statement was filed way back in the year 2004. And the will said to be executed by defendant number 1 was on 8/2/2003. There is not even a whisper in the written statement about the defendant number 1 having any defendant number 1 having any extra affection to defendant number 7 to execute a will in her favor. On the other hand, the defendant number 1 has specifically stated that neither the plaintiffs and defendants would have any share in the suit property, making the intention in the peculiar facts very clear that defendant number 1 did not intend to give away the property to the defendants. In order to prove the will, which is marked at Exhibit B20, defendant number 2 is examined as DW1. The evidence of DW1, which is brought to the notice of the court by the respondent, would indicate that he's mentioned that he has got knowledge about defendant number 1 executing the will in favor of defendant number 7. Whereas the evidence of DW3 and DW4, who are said to be the attesting witness during their chief examination, have stated that the will has been executed by Minijamma after the contents were read over to Minijamma. She has affixed her LTM to the will. The cross-examination of DW1 at page number 115 is as under. The cross-examination of DW1 indicates that before he went to put his signature on Exhibit B20, Minijamma had already put her LTM, and defendant number 2, Shiv Kumar, who was present, stated that everything is ready and inspected all of them to move. All of them to move. The trial court found that there is contradiction in the evidence of DW3 and DW4. And the deposition of DW3 and DW4 regarding the proof of the will, the evidence placed by the defendants was not sufficient to dispel the suspicious circumstances that surrounded the will, surrounded the execution of the will by defendant number 1 in favor of defendant number 7. One material aspect that needs to be considered is that earlier defendant number 1, defendant number 2, 3, and 4 filed the written statement. Subsequently, defendant number 2, 3, and 7 filed written statement stating that the will in respect of item number 4 has been executed in favor of defendant number 7 during her lifetime. The defendant number 7, who is the propounder of the will, has not let in any evidence, nor has discharged the burden which was casted upon defendant number 7 to prove that there was an execution of will in favor of defendant number 4. The contest was made by defendant number 2, who was present at the time of execution of the will in favor of defendant number 7. And is also one of the witnesses. The active participation of defendant number 2 made the trial court and the first appellate court to arrive at a conclusion that the will executed, that the alleged will executed, that the alleged will is not executed in favor of defendant number 7, and the execution of the will is not being proved in accordance with section 63 of the Indian Succession Act and 68 of the Indian Evidence Act. The substantial question of law framed by this court, substantial question number 2 framed by this court, is answered against the appellant. Regarding substantial question of law number 1, the first appellate court modified the judgment and decree of the trial court by awarding motional partition in the share of Krishnaya, considering the law that prevailed at that point of time. In light of the decision of the apex court in the case of Vinitha Sharma versus Rakesh Sharma, the law is well settled that the daughter is entitled, is to be treated as a co-pastor and entitled for equal share in the ancestral joint family plan. The apex court in the case of also as held at para number as under. The plaintiffs 2 to 4, defendant number 8 are together entitled for 1/8 share. Heirs of defendant number 6 are entitled for are entitled for 1/8 share as held by the 1/7 share. 1/7 share. And defendants 2, 3, 4, 5, and 7 are entitled for 1/7 share each. And the substantial question of law number 1 is answered in favor of the plaintiffs. And this court passed the following order. The regular second appeal is hereby dismissed. The plaintiffs 2 to 4 and defendant number 8 are entitled for 1/7 share together. Together are entitled for 1/7 share. Loss of defendant number 6 together are entitled for 1/7 share. Defendant 2, 3, 4, 5, and 7 are entitled for 1/7 share each. Decree to be drawn accordingly. No, that's it. Mr. Shankar Reddy. Non-joinder, we will not say anything. Non-joinder of necessary parties. Yes, so that goes. How are you entitled for share? And there is already a partition, huh? Correct. He has purchased from his brother, right? Genealogy ಕೊಟ್ಟಿದ್ದ ನೋಡಿ. You mentioned about the genealogy, right? Sanjeevappa is the Have you produced it before this court? Illide mark appeal papers nalli ellide? Appeal papers nalli genealogy elli? 82. ಅಲ್ಲ ಇದರಲ್ಲಿ ಪ್ಲೇಂಟಿಫ್ ಡಿಪೆಂಡೆಂಟ್ ನಲ್ಲಿನೇ ಹೇಳ್ಬಿಡಿ ಇವಾಗ. Plaintiffs Yellama is the daughter of Sanjeevappa, na? Then Muniyamma is the daughter of Sanjeevappa. Parvatama is the daughter of so all are the daughters only. So we are only concerned with Sanjeevappa. I think Sanjeevappa had 2 wives, huh? Illa. One day wife. Correct. Muniyamma, Parvatama, Venkamma is her his wife. Correct. Savitra. So Yellama is plaintiff number 1. Plaintiff number 2. Okay. Now, your suit is for partition. Father. When was the sale? 9/12/2000. Yes. You were not included accordingly.
Even otherwise, if the property of the father, the property of the father, therefore the other family member is not. This property, family property. Because one document, because this property was standing in the name of my grandfather at the earlier point of time. So during the year 1935, but for non-payment of taxes, there was a forfeiture. Only position was not taken, but in the revenue record max of was entered. It is there 1935. My father, after the death of my grandfather, has paid tax in the year 1952. Subsequent to paying the taxes, the name of the family members came to be restored. So whether after restoration, after paying of taxes, whether it is deemed to be the self-acquired property of the father, or only after getting back the property, it assumes the nature of the property was existed earlier. But exhibit B17 is really different.
So then, at that point of time, it loses the character of the joint family after the repurchase or by paying tax by the father Sanjeevata. See, when he pays that amount, had the joint family had sufficient income to pay that amount to the forfeiture? Where is the recitals in the same? Exhibit B17. They said that it's the absolute owner. Whereas the vendors being the absolute owners having absolute right and title over the suit property or agreed to sell the suit schedule property from so and so.
has gone to second land of survey number 5 and
which property is more fully described?
refer to as scheduled property. Tata signs in the name of Karnataka in this ancestral property. Subsequent he demands the Tata of the scheduled property has related to serial number 1 vendor Mr. Sanjeevappa MR. Origin clarity. Device available. Moreover, the MR, it has been not produced by them. It is Pavati Tata Nella. It is a double standard.
Who pays the taxes? Now, there are two things again here. A person pays the taxes. He pays a tax. The property was forfeited. You take your example only. The property has been there in forfeiture. You are earning or you have got a separate income. You purchase or you give the tax or to that property. What it becomes? Will you still say that it acquires the property of the joint family? Even otherwise, if at all it is not paid from the joint family income, how do you say that? As you have to prove that the joint family possessed sufficient income to purchase the property, because the grandfather could not maintain the property, or rather the property was forfeited because of the non-payment of amount. Alva? See, after non-joinder. Dependent number 1 did not contest. This is very obvious that the plaintiffs have come to the court immediately within 20 days after the execution of the sale. How did they come to know about the execution of the sale? Immediately. They were not talking in good terms. Plaintiffs and the defendants were not in good terms. Mr. Shankar Reddy, you know the scope of the second appeal now. Yes, sir. As the court stated earlier, as to how this property was acquired by Sanjeevappa, he paid the amount. That is not in dispute. Out of
joint family income.
that is burden is on you. Burden is on you.
Initial burden is on you.
Yeah, how do you discharge it?
The non-payment of taxes only. However, you have to put later. Subsequently, I place reliance on the state. Even according to the state, it is not the self-employed.
So the wordings in the first para is not very clear. So what it says, second paragraph says.
All the paragraphs are not different, but all the family members are hardly executed the same.
Vendors being the absolute owner, they have just been signatories, the witnesses to that. So who sells the property? Sanjeevappa. Sanjeevappa sells the property. Alva. Other daughter and other sons become a signatory to that sale deed. They have not executed the sale deed. See, when a person purchases a property, if there are other legal heirs or the person has got daughters and sons, the purchaser will say, "Ellarnu party ಮಾಡ್ಕೊಳ್ಳಿ, sign ಮಾಡ್ಕೊಂಡು ಬಿಡಿ," then problem should not arise.
The remaining amount has been paid to the family members. They have checked and cash.
There should be a provision now to make claim damages against your own brothers who have executed the sale deed. It is there. If you want to go and take it from your brothers. So Shankar Reddy, you made your best effort. Which is that judgment you want to say? On what proposition of law? Have you taken some contention in your written statement regarding that aspect? That this was how it has happened. You just filed a suit for partition. You did not say anything about it. Then you should, when you come to the court, you have to be specific and say as to how this property was acquired by Sanjeevappa, and it is not the self-acquired property, but it is the joint family property. And how did this joint family property and whose name it was standing, you should have stated in your plaint. Your plaint is just a simple suit for partition. Nothing, not even a whisper about what has happened. It is for you to produce.
Subsequently, in an auction.
How is it? Your suit, you should have said that this property belongs to your grandfather. It is not the exclusive property of Sanjeevappa, and he had no exclusive right to sell the property. You don't even say anything. You just say you are entitled to a bunch of share in the suit property. Draw madi. Yes. Where? Page number? Yes. Yes, yes. Okay.
Production of mutation leads to extent. Number one. The positive assumption not that the positive finding that has been given by the report not
Yes.
Actual not what. You
can complete your argument afterwards. Page number? Yes.
Number one, you are getting the land, number one, factory. Therefore, addiction that has been is the constituent was of only, even a factory. That will not be. But she also you also admit the Tata and Rani are made purchase the same. The admission of PW also provides the case of dependence. Item number one is therefore for dependence. Though he has not been negotiated. Therefore, what we read is on certain solution that has been same but this particular document I do not know. Such self of the decided data regarding self of the document. Examination is number one, he was getting the land cultivated and he states that for the past 50 years the two data has not been cultivated. Therefore, the suggestion that has been put with the other side was statement for the therefore the children are cultivating all people. This also be directly referred to paragraph number 19, but internal page 8. Even we must, the study number 674, to take two data number one for value. In the children of the was elected to be Therefore, he not he gives an answer contrary to the guidelines of the document. You also do not appreciate it. But particular is taken away. This is rely on another document, not does not depend to say. You have only assumption moral assumption. The same page word what the for 8 links to the there is a different number thing. It is that it was over not only the game. The ownership of the player to do with the two property, the asset and property. But owner does not shift not definitely increase of his world. Here reciting the say we will not do item number 1 of the food property and the asset property of the player.
You have to place sufficient evidence.
That would document is admitted by both parties.
Titles of the documents cannot be an exclusive proof to show that it is the joint family property of.
Fathers may take to be entered in the residence. So, the father's name, because he paid father will be entered in the house.
You don't dispute that defendant number 1 has paid taxes.
No, he can pay taxes, not say anything like that. But with the paying of taxes itself not get straight to a particular party, but it was to be examined.
Yes.
This is also the very refer to the page 21.
Yes.
I am reading the first line of the different multiplier here all these people and therefore is one way. It will even further state that we are opening genealogical tree of different number 1. We have not mentioned about the name of his daughter in the genealogy. We are going to say genealogy. But if this particular document would be produced, then there would be every possibility that the father and other family members would not have disclosed. Our existence is not saying that we are also available. Now, this particular document, not if it is produced, and if the genealogical tree indicates 9 names also, then what is that we go? Therefore, the observation that I made, saying that the purchase of not has not used the genealogical tree, clearly indicates that he acknowledged that particular. There are other family deliberately.
Says this property is not the joint family property. The question comes afterwards, after all this. Both the courts are held, it is not the joint family property. It is the self-acquired property. Is it not?
He had filed an application for locating the other family. He passed through the judgment. In the course of the judgment, not the filing of the application is also the suit is the impeding application that has been filed to impede the other family because is also dismissed. In the course of the judgment, a finding is rendered. In the trial court, I am not impeded the other family. Therefore, the suit for partial court.
In first appellate court order. 20. Yes. So who paid this revenue? Who paid the revenue? Which other family? Father is Sanjeev Appa. You said Sanjeev Appa was only 8 years. Grandfather, huh? Where is that material to show that grandfather's name was? No, forget about, they are assuming that dependents are not there. How do you establish? In the event the dependents were not there, how would you establish that this is the joint family property of Sanjeev, of the family of the...
But I would have placed on record not the party CH-27 and not the entry that came to give the name of my father.
Where is that? Where is that document? B1 is what? It is of the land revenues recovery proceedings which were initiated, and the grandfather of yours could not pay that land revenue, and in light of that, the Sanjeev Appa paid the land revenue. That is not in dispute. In the event the taxes were not paid by dependent number 1, what would happen to the property? That is something else. Again, you cannot go in a...
Because clear picture as to what is the nature of the property.
Yes.
They cannot dispute their own document. They have not examined any other such a decided not it is it is only their assertion not in the court of in the evidence first time. And as your worship kindly appreciate 82 of the evidence side. Evidence of oral agreement. What to be a contrary, what is there that part. I don't know the means of contract. That or other disposition of property or any other required by law to follow the document. I will do according to the law. Yes. Between the party, they say that all their representatives for the purpose of contradicting, varying, adding or subtracting. The thousands of the evidence that is there. It is for them to not. Exactly to know about that the reciting that is there and what is the reply.
Yes.
Now, when this particular the lordship not right out of the not right out of then I'm not before we go effect. We have filed an amendment application. Because they took up a contention that there was one other property that was all of these are not filed up for. But that was not added. Therefore, now we filed an application we include the other property not was according to the definition was available. And that particular application was also taken along with the next. And along with checking the application was even the amendment application.
So the pleading application also was rejected.
Rejected in the main application. By taking up the argument form, there were two applications that were required to be considered along with the main application. One was for including the other family members who were left out. The other is for adding one more property more which was left out.
On what ground this application was rejected? On what ground? It's not necessary. What was the reason assigned by the first appellate court to dismiss the application for impleading?
Because I did not choose to file an application before the prior court. To catch up, I filed an application before the first appellate court. We also may kindly refer to internal main body, the first appellate court. Internal main body, not a paragraph. Third, there was a need for being placed on the page. There was said all this ground also the batch of the same mistake. The plaintiff is like a plaintiff in the appeal by PA. From the same the observation partial partition and filing the present application for partition is common. Another idea has been filed under order 1/1066, saying to permit the plaintiff to include a part of the different members of the level. However, the plaintiffs are only the universal of the G3, even with the original proposal of Gopalappa and his wife Yadama at high children, the Papa, the Jura, Cinema, Nagama. This is the important. All the grounds non-feeding children of business proposals for inclusion of the proposed inclusion of not being.
It is just a passing remark that the suit is not dismissed on that ground, non-inclusion and but then the first appellate court has rectified that.
First appellate court has dismissed the application.
Dismissed your application, but doesn't dismiss your suit on that ground.
You could say, there is already a binding.
No, he says mere inclusion of this proposed dependent 711 and the inclusion of item number 4 will not be helpful. What is their defense? Oh.
Sisters of the plaintiff, they are not being included in this court. And one of the properties that is still available is available.
No, that is not the ground for dismissing of the suit. That is not the ground for. That is on technical. Come to again the next para 18.
Right. They are the changes creating oral and documentary release of substitutional property or properties of Gopalappa. It is not a case of making the property of Gopalappa divided. How the children of Gopalappa it is not a case of making the substitutional property or now it is to be presumed that the two properties of Gopalappa, certainly all these children should be made as part of. Despite the knowledge of the exhibit given for this that Gopalappa and other children, Papa, Sunama, Nagama, other brother and sisters of my father. But they are not being made as part of. So, even of the right and order of the they did not make a question because the children of Gopalappa. Quite the observation that the cross examination PW4 stated that the union under was being cultivated to the wrong part. The evidence of PW1 establishes whether or dependent on the one by right, having interest in the subject matter without being made in matter. party to the suit without their being met, the other children of both qualified as parties to the suit is backward on matter. Here, right to the customary court to the law of the not just the father. My father's brothers also are cultivating the land, they are also. It would be not a standard, historical and not would be getting a very less share of that. All the conventions will be accepted.
Yes.
Therefore, I would say not that the court also would not be rejecting only. How we cover the petition, I not get this particular problem. I will declare a question of the property. It was not to be made as object. 5/4 is one property, 5/2 is another property, and there are two village sites. And insofar as 4 properties not the 3 properties will get treated. Thereafter, we realize not that there is one more property. We try to add that particular property also, if for some reason, if the courts do not will come to the conclusion that I am not entitled for share, this property that I want. Then regarding the other property, item number 2, 3 and 4.
Which is that application I number? To include item number? That is the including application. Which is the application seeking to include the item number 4 only. 2 and 3 is already there. 2 and 3 ideyala? But the reasoning of the first appellate court in dismissing the application for non-inclusion or non-including the other necessary parties is wrong. No, other item, whether it is joint family, ancestral. 4 and 5. We'll get the records. We will see. Registry to secure the records forthwith. List this matter on date. We will see the records of that. If it is for defendants 4 and 5, they don't have a case. If they say it is the grandfather's property, then they would be entitled.
Later, I contained in my case that there's 2 properties, 5/4 and 5/2. Then they amend their case that they include item number 2 and 3, which is owned by independent of 4 and 5.
They were not claimed. We'll give you a synopsis by next date, along with the details as to how they have sought to include. The self-employed.
And when he is alive, because the land is very, then how they get purpose and the life is actually
This court will correct that. Continue ಮಾಡಿ ಇನ್ನೊಂದು ಮಾಡ್ತಾ ಇದ್ದಾನೆ. Next. Well. ಇದರಲ್ಲಿ ಹಾಕ್ತೀನಿ.
Number 14.
Yes. Is in the absence of respondent number 1A, what happens? We heard this matter for such a long time. Please, give them. Memo of retirement is filed by HR Vasudha, Learned Counsel appearing for respondent number 1B, along with the acknowledgement for having served the notice on the respondent number 1B. Memo of retirement is taken on record. HR Vasudha, Learned Counsel is permitted to retire from the case as counsel appearing for respondent number 1B. Issue court notice to respondent number 1B, returnable by 13th September. Registry to delete the name of HR Vasudha from the process. If you were hearing that appeal, you would have refrained from hearing this appeal. Yes, next.
Number 5, serial number 5, household matter. Dear Papa.
No. Admission. Serial number 5. Yes. You are the defendant plaintiff.
Gaurama is the first wife of the first defendant. There was a divorce. And the defendants number 2 to 4 are the children of Jayamma, who is the second.
So this Kade Gowda had 2 wives.
But in another case, the first wife was divorced.
So no dispute about it. No dispute about it. Lakshmi is the wife.
The judgment did what it was decided in terms of a compromise, but specifically there is no order as to the divorce. But forgetting the fact that it was a 13-week petition, permanent alimony was given, and the finding of the court below is that because it has a serious bearing. This divorce is upheld, the defendant number 2 to 4 will become the legitimate children. And even if the property is held to be ancestral property, then they will also have a share, 1/5 share they will get. Now the suit is declared holding the parents ancestral property, and because she is the legitimate daughter, half share has been granted. And one more aspect is there are serious contention with regard to the nature of the property. And the appellant gets the property purchase of a partition. Section 8 was applicable. That also has not been considered. Mine aspect, even assuming that it's an ancestral property, then 1/5 share only has to be granted.
Now the trial court has granted half share.
Half share. That has been confirmed by the Lord office. The issue that the records are required to be considered whether the MC petition which ended in a compromise, whether it has been considered as a divorce or not. That is decided, I will get whatever share.
There is that issue regarding that.
No issue has been that only the number.
Additional issue number 1.
No, additional issue, page 40, page 40 itself is fact. Yes, learning the knowledge like
yes.
Learning the knowledge because of the country ಬಾಲ್ಯ ತಾಯಿ ಮತ್ತು ಒಂದನೇ ಕೃತಿವಾದ ವಿವಾಹವನ್ನು ಆಗಿದ್ದು ಅನಂತರ ಒಂದನೇ ಕೃತಿವಾದ ತೀರ್ಮಾನವನ್ನು ಮದುವೆಯಾಗಿದ್ದು 2 ರಿಂದ 4ನೇ ಕೃತಿವಾದ ಮಕ್ಕಳು ವಿವಾಹಿಸುತ್ತಾರೆ. Then may not be that being held there.
Yes.
Partly in affirmative.
So the substantial question of law would be whether the courts below were justified in overlooking the compromise arrived before the Lok Adalat on 26/6/2003 and holding that during the subsistence of marriage, the children from the second 2 to 4 are born. The appeal is admitted to hear the following substantial question of law. Whether the courts below were justified in overlooking MC 7 of 2003, the divorce petition entered between the first defendant and mother of the plaintiff before the Lok Adalat on 21/6/2003, and arriving at a conclusion that the first marriage is still in subsistence and the children born to the children dependent number 2 to 4 born from the second marriage were illegitimate children. Whether the first appellate court, whether the courts below were justified in decreeing the suit of the plaintiff and holding that the plaintiff is entitled for half share in suit item number 1 of the suit item number 1. Whether the judgment and decree of the courts below suffers from perversity and illegality, warranting interference by this court in this regular seconds. Admit, call for TCR. Paper book dispensed with. List the matter for final hearing. Yes, what is that? Yes. Number 1 of 2017. The drawing of final decree proceeding is stayed pending consideration of the sub.
Then number 7.
Mr. Jaydeva. What is your problem today?
Yes.
Modi, below 2 years that is available to be raised by the tenant because the bill is issued to the tenants. Now, the tenants have already vacated. You duddu katti, you recover it from your tenant. Now, what to do? You have given the premises. Meter is given to the premises. Again, now that you have already paid, your vendor has already paid the amount. Alva? Vendor pay madidar alva? ಅಲ್ಲ ಇದು 5 lakhs ಇಲ್ಲಿ ಮತ್ತೆ ಏನೋ ಡ್ಯೂ ಅವ್ರು ಮಾಡಿದ್ದಾರೆ. That has been. So fresh connection is already been given. Yes. ನೀವು ಅವ್ರ ಕಡೆಯಿಂದ ಕ್ಲೇಮ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಲ್ವಾ? ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ ಹೇಳಿ? ನೀವು ರೆಂಟ್ ಮೇಲೆ ಕೊಡ್ತೀರಾ ಪ್ರೆಮೈಸಸ್ ಅನ್ನು. You leave it to the tenant to take all the facilities ಏನೇನ್ ತಗೊಳ್ತೀರಾ ಅಂತ. At that point of time, NOC was not necessary. That doesn't mean you are not even liable ಅಂತ ಬರೋದಿಲ್ಲ. ಹೌದಲ್ಲ? ಅದಕ್ಕೆ ಕೇಳಿದ್ದು what was your problem today ಅಂತ. ನಾಳೆ ಲಿಸ್ಟ್ ರೂಟ್ 2 ನ ಡಿಸ್ಕಸ್ ಮಾಡ್ತಾ ಟುಮಾರೋ ಅಲ್ವಾ? ಇನ್ ಸ್ಯಾಟರ್ಡೇನಾ? ಟುಮಾರೋ ಫಸ್ಟ್ ರೌಂಡ್ ನಲ್ಲಿ. ಸ್ಯಾಟರ್ಡೆ. ಸ್ಯಾಟರ್ಡೆ ಅದರಿಯರು. Yes, where is madam? Renuka?
Cell number 8 for final hearing, list 3. Lakshman Rao.
Saturday. Okay. Yes.
Cell number 12. Krishnamurthy Hatyada.
Please. First of all, I am sorry. In the morning, I submitted that I would be coming in person and arguing the matter. Kindly excuse me. Al maatiಗೆ ಮುಟ್ಕೊಳ್ಳಿಕ್ಕೆ ಆಗಲಿಲ್ಲ. The reason is, in the meantime, ಅದು man proposes, God disposes ಅಂತಾರಲ್ಲ ಹಾಗೆ. In the meantime, I got some news regarding bereavement in the close circle. I am not in a position to appear. However, and now that I have appeared through VC, let me start. I have already filed. I don't know whether my learned friends, I have informed them that I will be appearing through VC. 2:30 ಅಂತ ಹೇಳಿ ಹೇಳಿದ್ದಾರೆ. VC ಬರ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ದೇನೆ, ಅವರಿಬ್ಬರಿಗೂ ತಿಳಿಸಿದ್ದೇನೆ. Anyway, this is shall I start, Mula?
Yes. How long will you take to argue this matter?
ಅದು at the time of admission itself, this honorable court heard the matter for 2 days. And the matter
will hear this matter for 1 day, 1 week.
ಇಲ್ಲ ಹಾಗಿಲ್ಲ ಎಲ್ಲ ನಾನು ಫೈಲ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದೇನೆ. There are several questions of law framed by this honorable court. Kindly ಅದು ಹೇಳೋದಿದ್ರೆ kindly see the order dated 7/12/2016. All important questions of law, all supported by judgments of the Supreme Court and our High Court. And of course, according to me, injustice has been done to my client. My client is in possession of the property even as on today, admittedly, by virtue of the agreement in 1995, agreement of sale, exhibit D8. I have kindly take the synopsis, dates and events filed by me on 23/7/2021 and points for consideration filed on.
Mr. Harsikar avare.
Please.
Others, this matter may take some time, so others need not wait. 17, huh? 17 ನಾಳೆ ತಗೊಳ್ಳೋಣ. ನಾಳೆ ಅಲ್ಲ, ಒಂದೇ ನಿಮಿಷ, just a moment. 17 tomorrow, 18 ಇವಾಗ ನಾಳೆ ಮಾಡ್ತೀರಾ? 18 is moved by whom? Respondent. ನೀವೇ ಮೂವ್ ಮಾಡಿದ್ರೆ ನೀವೇ ಟೈಮ್ ಕೇಳ್ತೀರಿ. ನಾಳೆ tomorrow. Yes. 18, 19.
19. Nakarajan Bhaiya.
17 Mr. Alva ಅವರು ಇಲ್ಲೇ ಇದ್ರಲ್ವಾ? Age is next Thursday. He insisted for tomorrow. So kindly inform him. Kindly inform him. So we'll take it on 17th at 2:30. 2:30. On 5th or 4th. 2:30. So just inform Mr. Alva. Just a moment. 18. So this is on tomorrow. 18th is tomorrow. Nagarajappa? 19.
19. Nagarajappa age. Number 19.
It's called mood ಅಂತ. ನಾಳೆ ಹಾಕ್ಕೊಡಿ. This matters ಅಷ್ಟೇ ರಿಪೀಟ್ ಮಾಡಿ. Second appeals, final hearing. Vijay Kumar? Vijay Kumar? Tomorrow. Naale.
22.
Mahesha? You are ready? Tomorrow? After tomorrow, ಬೇರೆ matters. Writ ಹಾಕೊಂಡಿದ್ದೀವಿ. 5-9.
Number 24.
Mr. Yes. 24 or 23? 23 ಏನ? ಹೌದಾ? ಸಂಪತ್. ಅಲ್ಲ ಅವರು ತಗೋತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. ಮಿಸ್ಟರ್ ಸಂಪತ್ ಕುಮಾರ್ ಶೆಟ್ಟಿ ಅವ್ರು ತಗೋತೀನಿ ಅಂದ್ರೆ 2:30 ಬರ್ತೀನಿ. ಮಾತಾಡ. ನಾಳೆ ಹಾಕೊಳ್ಳಿ. 23 tomorrow. 24? Tomorrow. Serial number? Serial number 16 of second list. It was not called. We take up other matters on Wednesdays. So second appeals we give 2 days. In spite of that, we are not finding it. 16. It's not framed. Additional substantial question of law. Have you filed an IA for that? IA is filed or memo is filed? Yes. And we have to hear to frame this additional substantial. So tomorrow let him start. Nale. Yes, tomorrow. Oh, your colleague mentioned to report settlement something. ಏನು ಮಾಡಿದ್ದೀವಿ ಅದರಲ್ಲಿ ಸೀರಿಯಲ್ correct. That is not very appropriate. Oh, because she was not in a very good condition. We said you pay some amount to her, not that. Is there anything she's receiving from that amount? You inform the other side. Anyway, or 4-9 it is this. Yes. Yes, Mr. Hasegar,
Please.
24.
Take
you inform the other side. No, if she was pressing it for tomorrow, ಆಮೇಲೆ ಬನ್ನಿ ಹೇಳಿ ಅವ್ರಿಗೆ ಹೇಳ್ಕೊಂಡು ಬನ್ನಿ. You inform them and come. Yes, you were not present when the matter was. The matter was already called in the first hour itself. We noted your absence. It is listed when? Martin percent. Hearing on 9. 17?
9. 17 October.
It's listed on 17/9. Yes. Your matter is adjourned to next week. 9th. ಅಲ್ಲ ಸ್ಯಾಟರ್ಡೆ ಹಾಕೊಂಡಿದ್ದೀರಿ ಸ್ಯಾಟರ್ಡೆ ಆಯ್ತು 9th ಹಾಕೊಳ್ಳಿ 9th ಆಯ್ತು ಎಸ್ ಮಿಸ್ಟರ್ ಹಾಸ್ಯಗಾರ್ ಅವರು ಹೇಳಿ
please kindly take the synopsis filed on 23/7/21 and the points for consideration filed on 16/2/2016. In fact, that was filed prior to the framing of the substantial questions of law by the court.
What is that? Screen ಒಂದ್ ಸ್ವಲ್ಪ ಅವ್ರ ಕಡೆ ತಿರುಗಿಸಿ ಡಿಸ್ಪ್ಲೇ ಆಗ್ತಾ ಇಲ್ವಾ ಚೆಕ್ ಮಾಡಿ yes ಹೇಳಿ
16/12/2016 I have filed points for consideration and that was before framing substantial questions of law. Thereafter on 20
the defendant or the plaintiff ಹೇಳಿ you are the defendant you are the defendant or the plaintiff.
Yes, that is explained in this I have filed on 23/7/2021. Kindly take that. Kindly take that. I have explained everything in that.
Yes, ಹೇಳಿ
please ma'am. There are two suits. In one suit, that is OS 507 of 1997, the appellant is plaintiff.
There are two appeals ಇಲ್ಲಿ
ಹೌದು there are two suits, two appeals and two regular second appeals. ಅಲ್ಲಿ ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ ಎರಡು.
yes 507 of 97
ಹೌದು. In that suit, that is a suit for specific performance of the agreement of sale, exhibit D8, executed by one Krishnadas.
Yes.
RA number 597 of 2011 arises of that suit. Here, RSA 9 of 2016.
Yes.
And the other RSA 8 is in respect of OS 318 of 1999. That's a suit filed by Srimati Sarojamma, the defendant in our suit. That is a suit for possession of the property. She says that there is a sale deed executed by Krishnadas, the person who has executed the agreement of sale, executed in my favor in 1995. That is the sale deed dated 9/12/1998.
Your agreement is dated
14/5/1995. ಅದನ್ನೆಲ್ಲ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿದ್ದೇನೆ ಕೆಳಗಡೆ ಇದರಲ್ಲಿ.
ಅಲ್ಲ ಹೇಳಿ 14/5/1995. ಆಯ್ತು ಹೇಳಿ.
And RA 596 bar 2011 arises out of OS 318 of 1999. Here it is RSA 8 of 2016.
Yes. So in RSA 9 of 2016, you are the plaintiff.
Please.
And RSA 8 of 2016, you are the defendant.
Yes.
Defendant and the plaintiff.
Yes. ಅಲ್ಲಿ ಮತ್ತೊಬ್ಬರಿದ್ದಾರೆ. Respondent number 1 is Deepak, who is the son of Krishnadas, the person who has sold the property to me.
So he is the legal heir of Krishnadas.
Howdu Krishnadas. Respondent number 1 in the appeals.
Yes.
And respondent number 2, Sarojamma, is the plaintiff in the other suit.
Yes.
318.
Very well.
Now, before the plaintiff,
you are in possession of the property based on the agreement of sale.
Howdu, on the basis of that agreement of sale dated 14/5/1995, because even prior to that, the facts and brief ಆಗಿ ಒಂದ್ಸಲ ಹೇಳ್ಬಿಡ್ತೇನೆ. One Krishnadas, very brief ಆಗಿ, one Krishnadas was the owner of the scheduled property. That is an admitted fact. there were two premises, 1424 and 1425. My client Radha, she was not in possession. Her father-in-law, one Kattige Puttaswamy, also called Puttaswamaya, was admittedly in possession of the suit property from the last several years.
As a?
Last several years.
As a? On
as
what
basis? As a tenant. As a tenant. In respect of the other portion, of course, we are not concerned. There was another tenant by name Narasamma. After some time, this Krishnadas thought of filing an eviction petition against both the tenants. He did file, and eviction order was admittedly passed.
When was the HRC proceedings initiated against the
against ನಮ್ಮ ಪುಟ್ಟಸ್ವಾಮಿ ಕಟ್ಟಿಗೆ ಪುಟ್ಟಸ್ವಾಮಿ ವಿರುದ್ಧನೂ ಮಾಡಿದ್ರು.
ಯಾವಾಗ ಮಾಡಿದ್ದು ಅದು?
In 1982. ಹೌದು. And eviction order was passed. ಅದು ರಿವಿಷನ್ ಆಯ್ತು, ರಿಮಾಂಡ್ ಆಯ್ತು, ಮತ್ತೆ ರಿವಿಷನ್ ಆಯ್ತು. That matter came up to High Court. And ultimately eviction order has been confirmed.
When did it conclude?
In 1994 or 95. By the time the matter was concluded here, ಅದು ಗೆದ್ದವ್ ಸತ್ತ ಅಂತೇಳಿ ಗಾದೆ ಹೇಳದಂಗೆ, he was financially in grave financial difficulties. ಸಂಸಾರ ನಡೆಸ್ಕೊಂಡು ಹೋಗ್ಲಿಕ್ಕೂ I am not saying this without any evidence. This is admitted by his son Deepak, who is respondent number 1, who is examined as DW1. DW1, yes. I will take your lordship through all those evidence, etc.
From prima facie, now what you have stated, we will say something now.
Yes.
Till 1985, you were in possession as a tenant.
As a tenant. When the matter reached the High Court,
there comes an agreement on 14/5/1995.
That is because he,
after so much of tussle between the landlord and tenant, this landlord proposes to sell the property to you.
Because he was in grave, that is the reason, grave financial difficulties. He agreed to dispose of only one portion in favor of Puttaswamy. He said,
Mr. Hasegar, you were in possession of only one portion, right?
How the one, the 1424. He decided to sell that portion in favor of Radha, the appellant in this case, who is the daughter-in-law, because they were living together. Puttaswamy, his son Narayana, and this Radha and her children. He thought of disposing of the property. 70,000 he agreed, 40,000 he received. And this agreement dated 14/5/1995 was executed by him, and we were allowed to continue in possession of the property. That is the case made out, and that is admitted by the other side. Then he did not execute the sale deed. At that stage, we filed this suit, OS 597 of 1997. There was an order of status quo passed in the original suit. After getting notice, and it is an admitted fact that he was aware of the pendency of the suit and the status quo order. It is admitted, it has come in the evidence of DW1. I will take your lordship through that. He, suppressing the fact that he has executed the agreement of sale and Radha has been allowed to continue in possession along with Puttaswamy, he is alleged to have executed, alleged to have, I will take your lordship through the exhibit P1. Signature yavudu tally agudilla. Anyway, that is marked in evidence. We will have to assume that it has been executed. He executes a sale deed on 9/12/1998 in favor of Sarojam.
Yes.
That is plaintiff in the other suit. And interestingly, in that sale deed, it is mentioned that possession of the property, vacant possession of the property has been delivered to Sarojamma, the plaintiff in the other suit. Sarojamma in the plaint she states vacant possession has been delivered, and that is what the registered sale deed says also. Much against the contents of the document, registered document exhibit P1, she says physical possession was however not delivered because Radha was in possession, and hence only symbolic possession was delivered to me by Krishnadas. And she further says,
Yes, you being in possession is not disputed.
No.
It's not disputed by anyone because there were the proceedings initiated till 1995.
Yes.
After that, was there any execution petition levied by the?
Yes. Execution case 14 of 95 and 32. That is pending. During the pendency of that case, he executed this agreement. What he said is, he would take only symbolic possession, or he would inform the court that you are allowed to continue in possession of the property by virtue of this agreement. Of course, one mistake committed by this Radha, the appellant, is that they believed him and they did not appear before the executing court and inform the court. Here is the agreement. We have been allowed to continue. There are documents to show that we have been in possession of the property subsequent to 1995 till even to this day they are in possession of the property. They did not, of course, inform the executing court. Taking advantage of that, Krishnadas is alleged to have taken possession of the property pursuant to exhibit P6 and P7 on 6/7/1995. And suppressing this fact that there is an agreement, as I already submitted, he executes the sale deed in 1998 in favor of Sarojamma. And Sarojamma, to suppress the fact that she is not in possession of the property, she cooks up or concocts a story saying that subsequent to delivery of possession as per exhibit P6 and P7 on 6/7/1995, Radha trespassed into the property subsequent to 6/7/1995. Absolutely, there is no evidence. That is also admitted by both of them. And on the other hand, their contention is directly section 92 of the Evidence Act. Your Lordship is well aware. They can't contend contrary to the contents of a registered document wherein it is stated that vacant possession is delivered. They will have to show that subsequent to 9/12/1998, that is the execution of the sale deed, I dispossessed Sarojamma. They do not do so. On the other hand, they say this Radha has trespassed into the property in 1995. How can she get possession of the property in 1998? Instead of appreciating this, the trial court, mainly on 3 grounds that is mentioned in that point for consideration, dismisses the suit filed by me. Yes, that is all stated in the points for consideration. The trial court dismissed my suit principally on the ground that the agreement of sale is not a registered document. That is one ground, and hence that can't be the basis of the suit. Second ground is that the purchaser, that is Radha, has not signed the agreement.
Purchaser andre ನೀವೇ.
Now say mandlilla, that is one of the grounds to dismiss my suit. Second ground is that it is not a registered document. Both the grounds are opposed to the judgments of the Supreme Court, which I have already produced before the Honorable Court. And the third ground is that the trial court, it says it compares the signature on Exhibit D8 and the Wakalat and the return statement filed by Krishnadas in the suit, and it says the signatures do not tally. Court itself compares and holds that they do not tally. Principally on these three grounds, suit has been dismissed. All the grounds on which the suit is dismissed. In my submission, of course, I will take your lordship through all those decisions, are against the judgments of the Supreme Court and this on several judgments of this Honorable Court.
When did you file the suit?
That was filed on, yes, idರಲ್ಲಿ ಹೇಳಿದ್ದೇನೆ 6/7/1995.
6/7?
ಅಲ್ಲ
2012. 2012.
Suit was filed on
2012.
21/12/1997.
Yes.
21/12. I'm sorry. 21/12 ಅದು ಕೆಳಗಡೆ ನಾ ಬರೆದಿದ್ದೇನೆ ನಿಮ್ಮ ಇದರಲ್ಲಿ 21/12/97 ನಾನು ದಾವೆ ಹಾಕಿದ್ದು. And the learned appellate judge, when I file 2 appeals, he takes up both the appeals together. And according to me, it is not a judgment in accordance with Order 41, Rule 31 of CPC at all. I can read out from the judgment. He does not discuss any of the aspects, including the specific admissions made by the son of, because Krishnadas was not available to deny his signature. The evidence given by Deepak, who is colluding with Sarojamma, the subsequent purchaser, during the pendency of the suit. And based on that, he said, I will confine myself to only Exhibit D8, no other points. That is what is written in the judgment also. Seminal point to be considered by me is only in respect of Exhibit D8. And he does not consider the other points, and all other about 6 IAs were filed, producing documents to show that she has been in possession of the property subsequent to 14/5/1995. All those applications have been dismissed on the sole ground that they are filed with an intention to protract the proceedings. That also I will read to your lordship. My submission, the judgment is not in accordance with Order 41, Rule 31, and the rejection of the IA without assigning any reasons. ಇನ್ನೂ ಒಂದು ರೀಸನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದು ಯಾವುದೋ ಒಂದು ಹೇಳ್ಬಿಡ್ತಾರೆ 301. ಅದು ಎರಡು ಗ್ರೌಂಡ್ ಮೇಲೆ all the IAs have been rejected. 301. Because while making statement, I should be careful. 301.
Only single paper book is filed in both the appeals, right?
ಹೌದು. ಅದರಲ್ಲಿ ಒಂದೇ ಒಂದು ತಪ್ಪಾಗಿದೆ ಕೇಳಿದ್ರೆ ಪ್ಲೇಂಟ್ ಇನ್ ದ ಅದರ್ ಸೂಟ್ ಈಸ್ ನಾಟ್ ಫೈಲ್ಡ್. ನನ್ನ ದಾವೆಯಲ್ಲಿ ಪ್ಲೇಂಟ್ ಅನ್ನು ಹಾಕಿಲ್ಲ. Yes, 301 this is the reasoning. When peruse the applications which are 6 in number, when the promisee appellant has failed to prove the due execution, because that is the only point considered, validly of Exhibit D8, I am of the opinion that the documents now sought to be produced under these IAs will not inure to the benefit of promisee. Possession is annodake. The documents sought to be produced have no bearing. Further, there are no sufficient grounds within the corner of law made out by the appellant. It appears that those applications are filed only to protract the proceedings as such.
Yes.
That is one of the questions framed by this Honorable Court also on 7/12/2016. Now, with this background, I would request this Honorable Court, one request, I am not in a position to appear physically today. ಈ ಎರಡನ್ನು ದಯವಿಟ್ಟು ಪರಾಮರ್ಶಬೇಕು ಅಂತೇಳಿ, ಒಂದು ಈ ಸಿನಾಪ್ಸಿಸ್ ಫೈಲ್ಡ್ ಆನ್ 23/7/2021 meticulously I have prepared with reference to the deposition, the documents, etc., and the points for consideration filed on that is filed on 16/12/2016. In fact, ಅದನ್ನು ನೋಡಿದ್ರು at the time of admission. 16/12/2016. ಅದು ಎರಡನ್ನು ದಯವಿಟ್ಟು ತಾವು ನೋಡ್ಬೇಕು ಅಂತ ಹೇಳಿ ನನ್ನ ರಿಕ್ವೆಸ್ಟ್. And now with this time, the order dated 7/12/2016 may kindly be seen. the 2 days the matter was heard as though it was for final arguments. The learned judge reserved the same for orders regarding admission, and this order was passed. Your lordship got it, my lord?
Yes, yes.
May I continue with this?
Yes, for another 10 minutes you can continue.
Please, I think I can complete reading this. I think it is worth reading. Heard both counsel with regard to admission and framing of substantial questions of law. After hearing both the parties, the following facts and legal points arise for consideration. Originally, the disputed property bearing number 1424, situated, that is the suit scheduled property, situated at Masjid Road, 2nd Cross, Nazarabad Mohalla, Mysore, belonged to one Krishnadas, defendant number 2 in OS number 308 of 99 and defendant number 1 in OS 507 of 1997. The said property was leased to one Kattigai Puttaswamy, and another property bearing number 1425 was leased in favor of some other person. To recover possession from tenants, Krishnadas filed 2 HRC in number 147 and 148 of 1972, which were decreed in favor of Krishnadas. The tenants have also filed revision number 94 and 95 of 1991 against the order passed in HRC, and the same was dismissed. In fact, Vansala revision agi, remand agi, Yarane revision agittu early. It is alleged that Krishnadas has taken possession of the said property on 6/7/1995. Idರಲ್ಲಿ passing here for a moment, exhibit P6 and P7 delivery receipt ಅಲ್ಲಿ ಇವರ ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ, ಬಿಕಾಸ್ ಕಟ್ಟಿಗೆ ಪುಟ್ಟಸ್ವಾಮಿ ಸತ್ತೋಗ್ಬಿಟ್ಟಿದ್ರು. ಇವರು LRs ಅಲ್ಲಿ ಅವರು ಅಪಿಯರ್ ಆಗಿಲ್ಲ, ಯಾವುದೋ ಒಂದು ಪರ್ಸನ್ ಅಂತೇಳಿ ತೋರಿಸ್ತಾರೆ, ಅಂಡ್ ದೇರ್ ಸಿಗ್ನೇಚರ್ ಇಸ್ ನಾಟ್ ದೇರ್. ವಾಟ್ ಈಸ್ ಸ್ಟೇಟೆಡ್ ಇಸ್ ಮನೆ ಬೀಗ ಒಡೆದು ಅವರ ಸಾಮಾನೆಲ್ಲ ಹೊರಗೆ ಹಾಕಿದ್ದೇವೆ. ದಟ್ ಈಸ್ ಸಜೆಸ್ಟೆಡ್ ಟು ದ ಪ್ಲೇಂಟಿಫ್ Radha also by the plaintiff in the other suit, Sarojamma. I will take your lordship through that at a later stage. The said Krishnadas sold the said property in favor of Srimati P. Sarojamma. Plaintiff in OS number 318 of 1999. That is on 9/12/1998. And defendant 2 in OS number 507 of 97. After purchase, Srimati Sarojamma filed a suit OS number 318 of 99 as per the sale deed for seeking possession against Srimati Radha, first defendant in the so and so. The suit of Srimati Sarojamma was decreed and possession of suit property has been ordered to be delivered to Radha. Srimati Radha, plaintiff in OS number 507 of 1997, claimed that Krishnadas, the original owner, has executed an agreement of sale in respect of the property bearing 1424 in favor of Srimati Radha on 14/5/1995 and delivered possession of the same. She claims that she is the daughter-in-law of erstwhile tenant Kattigai Puttaswamy, who was in possession of the property bearing number. ಅಲ್ಲಿ ಒಂದು ತಪ್ಪಾಗಿದೆ, ಟೈಪಿಂಗ್ ವಿಷಯ 1425 ಅಲ್ಲ, 1424 ಆಗ್ಬೇಕು. ನಾನು ಇಲ್ಲಿ ಪೆನ್ಸಿಲ್ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಂಡಿದ್ದೆ. As against, there is no dispute about that, against which 2 appeals were filed in RI number 596 and 597 of 2011 were filed by Srimati Radha, challenging the decree granted in favor of Sarojamma and dismissal of her suit for specific performance of the agreement dated 14/5/1995. Both the appeals were also dismissed. Against that, these regular second appeals have been filed. Learned counsel for the appellant contended that the trial court has committed serious error in comparing signature of Krishnadas in Exhibit D8 with that of other admitted signatures. ಯಾವುದು ವಕಾಲತ್ತು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. That also cannot be done ಅಂತ ಹೇಳಿ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. ಅದು ನಾನು ಇವತ್ತು ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ದೆ, ನನಗೆ ಬರ್ಲಿಕ್ಕೆ ಆಗಿಲ್ಲ. ಒನ್ ಮಡ್ರಾಸ್ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಫಾಲೋಯಿಂಗ್ 1996 ಸುಪ್ರೀಂ ಕೋರ್ಟ್, ಅದೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿತ್ತು. ಎನಿವೇ, ದಟ್ ಈಸ್ ಕವರ್ಡ್ ಬೈ ದ ಅದರ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ which I have already passed on. Signature in Exhibit D8 with that of other admitted signatures without the help of the expert opinion, and held that the said signature is not that of Krishnadas. Trial court and the first appellate court have also committed serious error without appreciating Exhibit D8 in proper manner. That is, it is an agreement of sale executed by the said Krishnadas, and the appellant continued to be in possession of the property as she is the daughter-in-law of the erstwhile tenant Shri Kattigai Puttaswamy. The learned counsel for the appellant further contended that he made an application under 41, Rule 21 of CPC, which has not been properly, in fact, Vandella, by the First Appellate Court. He further contends that the suits were filed in the year 1997 itself by Srimati Radha, the appellant. But during the pendency of the suit, Krishnadas has sold the property, and the trial court has not considered the effect of Section 52 of the Transfer of Property Act. There was an order of status quo also. Per contra, the learned counsel for the respondent contended, this is very important, there is no question of executing any agreement in favor of appellant by Krishnadas, as he was not in possession as of the date of execution of the agreement. That is because, admittedly, Radha was in possession of the property. He only continued the possession. It is also contended that this agreement, said agreement, which is marked as Exhibit D8, if recitals are taken into consideration, it is as good as an unregistered sale deed. Therefore, there it cannot be construed as an agreement. My one nimisha niltene, ee Exhibit D8, it was objected to on the ground that it is not sufficiently, it is not registered document, stamp duty illa anteli. The court heard the matter, and there is an order passed on that objection, and I have paid stamp duty of 99,950 on that, and that is regularized. It can't be even used for collateral purpose, as the respondent Sarojamma has accepted the possession of the appellant. This is important. Even otherwise, the subsequent sale deed in favor of respondent Srimati Sarojamma confers right, title, and interest over her. And Section 48 also will come into play, because if it is construed as a sale deed, then my sale deed is prior in point of time than the sale deed in favor of Sarojamma.
Yours is an agreement of sale.
Allah, agreement of sale deed antela consider ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿ our contention. The contents of that is the contention is, it is also contended that the said agreement, which is marked as Exhibit D8, if recitals are taken into consideration, it is as good as an unregistered sale deed. Therefore, it cannot be construed as an agreement. If it is to be construed as a sale deed, then I have paid the requisite stamp duty. The whole thing is regularized as per Section 34. That is one of the contentions urged. And adukku judgment salaive. It can't even be used. Where Section 48 is, it can't even be used for collateral purpose, as the respondent Sarojamma has accepted the possession of the appellant. Even otherwise, that is Radha. Even otherwise, the subsequent sale deed in favor of respondent Srimati Sarojamma confers right, title, and interest over her. Subsequent sale deed antare during the pendency of the suit in the teeth of the order of status quo. Therefore, both the trial court and the First Appellate Court have not committed any error in decreeing the suit for Samarujamma and decreeing the suit of the appellant Radha. These are the contentions of the learned counsel for the respondent. On perusal of the judgment of the trial court and the First Appellate Court, and even accepting the argument of the learned counsel for the respondent, the question of law that arises for consideration of this court with reference to the possession of the property and the agreement alleged to have been executed by Krishnadas in favor of Srimati Radha, the appellant herein, doubt arises as to whether Exhibit D8 can be construed as an agreement of sale or an unregistered sale deed itself. That also becomes a question of law to be considered by this court. So far as the possession is concerned, the appellant claims that her father-in-law was in possession. Thereafter, she continued to be in possession from the date of the agreement. Subsequently, symbolic possession was taken by Krishnadas. However, possession continued to be with her. This possession has not been properly appreciated and considered by the trial court and the First Appellate Court. Therefore, I am of the opinion the following questions of law arise for consideration before this court. Whether the first question, whether the trial court and the First Appellate Court have committed any serious legal error in comparing the signatures of Krishnadas on the disputed agreement of sale, Exhibit D8, with that of other documents, that is Exhibits P1 and 2, and holding that signature does not tally with each other without the help of the expert evidence. Second question, whether the courts below have committed any legal error that the agreement of sale is not a registered document and not signed by the appellant. This is also fully covered. Therefore, the specific performance cannot be granted. This is Kalavati's case. Even if it is an unregistered agreement, that can be the basis of the suit for specific performance. Whether the trial court and the first appellate court have committed any legal error in construing Exhibit D8 as an agreement and not as an unregistered sale deed, and even it cannot be used for collateral purpose to ascertain the possession of the appellant, in view of the respondent has admitted the possession of the appellant over the suit scheduled property. Whether the first appellate court and the trial court have committed any serious legal error in rejecting the application filed with the appellant under 41 Rule 27 before the first appellate court without assigning any reasons in rejecting the same, though they are relevant documents, ought to be considered. Then, whether the trial court and the first appellate court have committed any legal error in not considering the possession of the appellant on the basis of the agreement of sale executed by Krishna Das. These are the substance. And I have filed an application. At this stage itself, I may additional question. I have filed an application. I think I will stop. I have filed an application IA1 of 2023 on 4/7/2023, requesting this honorable court to frame additional questions of law, if so considered by the honorable court.
Frame ಮಾಡಿದ್ದು ಸಾಲಲ್ವಾ?
ಅಲ್ಲ, ಅದು ಒಂದು 2-3 question, they are covered by judgment. And the thing is, the person who purchases the property subsequently,
ಇಷ್ಟೆಲ್ಲ substantial question of law ಆಗಲ್ಲ. There can be only 1, 2, at the most 3 substantial question of law. ಇಷ್ಟೆಲ್ಲ ನೀವು substantial question of facts ಇವ.
ಇದರಲ್ಲಿ ಒಂದು ಕ್ವಶನ್ ಅದನ್ನ ತಾವು ದಯವಿಟ್ಟು ಅಪ್ಲಿಕೇಶನ್ ನೋಡಿ. At least one question becomes relevant.
What is that?
Whether the judgment
question of law. We will not frame all other substantial questions.
Whether the judgment of the lower appellate court is in compliance or accordance with Order 41, Rule 31 of CPC, and the same can be sustained in law. Obviously and apparently, the learned appellate judge has not considered any other points except considering Exhibit D8. Other 2 points are also there. I leave it to your lordship's discretion for considering the same.
Yes.
With this, I may parted ಅಂತ ಹೇಳಿ ಮಾಡಿ ನನಗೆ 2ನೇ ತಾರೀಕಿಗೆ ಆದ್ರೆ ಪರವಾಗಿಲ್ಲ. ಅದರ್ವೈಸ್ ನಾನು 5ರಿಂದ 3-4 ನಾನು ಈಗ ತುಂಬಾ ಕಡಿಮೆಯಲ್ಲಿ ಕೋರ್ಟಲ್ಲಿ ಬಂದು ಮಾಡೋದು ಕಡಿಮೆ ಮಾಡಿದ್ದೇನೆ. ಎಲ್ಲ ಹಳೇದನ್ನು ಮುಗಿಸ್ತಾ ಇದ್ದೇನೆ. 5ನೇ ತಾರೀಕಿಗೆ ನಾನು ಊರಿಗೆ ಹೋದ್ರೆ ನಮ್ಮ ತಾಯಿಯವರ ಶ್ರಾದ್ದ ಎಲ್ಲ ಇದೆ ಗಣೇಶನ ಹಬ್ಬದ ಟೈಮಿಗೆ. 5ರಿಂದ 13 ಐ ವಿಲ್ ಬಿ ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್. 16, 17 ಯಾವ್ದಾದ್ರು ತಾರೀಕು ತಮಗೆ ಅನುಕೂಲತೆ ಇದ್ದಾಗ.
ತುಂಬಾ ಲೇಟ್ ಆಗುತ್ತೆ. We cannot remember. We may not have so much of memory as you all senior.
No, I am sorry.
So we will take it up immediately. We will take it up on 4th.
ಇನ್ನೊಂದು ಯಾವ್ದೊಂದು ಮ್ಯಾಟ್ರ್ ಇದೆ. ಸ್ವಲ್ಪ ದಿವಸ ನನ್ಗೆ 2ನೇ ತಾರೀಕಿಗೆ ದಯವಿಟ್ಟು ತಗೊಳ್ಳಿ.
ಅಲ್ಲ, ನಾಳೆ ಕಂಟಿನ್ಯೂ ಮಾಡೋಣ. 2:30ಗೆ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಬೇಡಿ ನೀವು.
ನಾಳೆ ಅದು ಕೆಲವು ಪ್ರಾಬ್ಲಮ್ ಹೇಳಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ ನನ್ಗೆ. ನಾನು ಒಂದು ಸುದ್ದಿ ಹೇಳಿದ್ನಲ್ಲ, ಹೀಗಾಗಿ 2nd ಆದ್ರೆ ನಾನು ಐ ವಿಲ್ somehow make arrange.
2nd ಅದು ಇವತ್ತು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಮಂಡೇ ಅಲ್ಲ,
ನನಗೆ
ಟ್ಯೂಸ್ಡೇ
ತಾರೀಕು ಎಷ್ಟು?
Tuesday at 4 o'clock.
I'm sorry, I could not get that date. Tuesday.
Tuesday is 3rd.
Please. 3ನೇ ತಾರೀಕು
4 o'clock.
ಸ್ವಲ್ಪ ಅಕಾಮಡೇಷನ್ ಮಾಡಿ ಮತ್ತೊಂದು ಕೋರ್ಟಲ್ಲಿ ಮುಗಿಸ್ಕೊಂಡು ಬರ್ತೇನೆ ಅಷ್ಟೇ.
4 o'clock ಬನ್ನಿ.
Please. ಅದೊಂದು ಹಿಯರಿಂಗ್ ಮಾಡಿ.
The learned counsel for the appellant in part to hear further based on 4 o'clock.
And ನಾನು ರೈಟಿಂಗ್ ನಲ್ಲೆಲ್ಲ ಕೊಟ್ಟಿರೋದ್ರಿಂದ ಒಂದೇ ರಿಕ್ವೆಸ್ಟ್, 4th ಆಗದೆ ಇದ್ರೆ 16, 17 ಯಾವ್ದಾದ್ರು ತಾರೀಕು ತಮಗೆ ಅನುಕೂಲ ಆಗಿದ್ದಾದ್ರೂ ಮುಗಿಸ್ಬಿಡ್ಬಹುದು ಬೇಕಿದ್ರೆ. ನನಗೆ ಸ್ವಲ್ಪ ಮಧ್ಯದಲ್ಲಿ ಸ್ವಲ್ಪ ಏನೇನೋ ತೊಂದರೆ ಅನಿವಾರ್ಯವಾಗಿ ಬರ್ತಾ ಇವೆ.
ನೋಡೋಣ, ನೀವು ಬನ್ನಿ 3rd ಗೆ ನೋಡಿ.
ಪ್ಲೀಸ್ highly obliged. Thank you for the patient hearing.
Yes. Is that? This number 4, serial number? Serial number 13. 13. It was not extended. None of you were present in the morning hour, I believe. Await service of course. Interim order granted earlier is extended till the next week. Yes.
Dr. Patel is still Harvard Pet.
Yes, Mr. Yadwad.
Yadwad.
No representation on behalf of the petitioner. This matter after 4 weeks.
For dismissal, the previously the order court ಮುಂದೆ ಇಷ್ಟು court notice ಆಗಿದೆ.
Madam, this court on 31/7/2024 directed the registry to intimate the party in person petitioner. And the matter was directed to be listed on 22/8/2024. There was no representation on behalf of the petitioner on 22/8/2024. And the matter was directed to be listed for dismissal on 29/8/2024, dismissal inverted comma. The party in person is not present even today. There is no material forthcoming about intimating by the registry to party in person. Yes. But registry is directed to furnish material as to the intimation to the party in person. But subsequently, the order dismissal, no representation. And they should have got the notice. We cannot even write that registry and the matter is listed for dismissal today. No representation on behalf. No, there is no representation. It appears that the party in person is not interested in prosecuting the petition. The petition is dismissed for non-prosecution.